Just so you know, we're all live streaming on YouTube now, so
I figured that out, so I'll be
see it in the
I'll
corner.
be good.
Okay.
It's a nice background.
Oh.
Yeah. Well, it's not quite in my district, but it's close. If I go to the end of my street, I can almost see it.
If I was more high tech, I'd have a better background, but I didn't dare to mess with it. So this is the office.
Yeah, somebody walked me through it. Otherwise, I would have a lit window behind me, which is not great for visibility. So I decided to bite the bullet and choose one of these fancy photos. I actually worked about 300 yards from that lighthouse for 30 years, so 37 years. So sort of my neighborhood, 2 miles from my door to that door. So
Wow.
Nobody wants to accidentally turn themselves into a talking cat while searching for the perfect background.
That was some great stuff. That was.
Good morning, everybody.
Good morning, Senator.
I think people will be joining us in just a moment, so we'll just give everybody a couple more minutes. Oh, there we go.
Morning.
Good morning and welcome, Representative Thorne.
Good morning. Thank you.
Yeah,
Just vote.
Representative Thorne is the newest member of our committee. We're delighted to have you join us. This is a great day to start.
Thank you. Happy to be here. Proud to serve.
Great, Jim.
We were just voting on a budget over at Marine Resources. So
You're doing double duty.
that's my other love, Representative Thorne. I'm a marine biologist by education.
oh, okay. Then watch this one. You're gonna love this one. I love your background.
Thank you. I'd like to tell you I painted it myself, but I'd be lying.
That looks very familiar, Representative Thorne.
I'd like to
it's
tell you
closer
I
to
was
than me.
I'd like to tell you I was standing there right now, but I'm not. So
Yeah. I just saying I worked in the neighborhood for a long time inside the park, so
yeah.
it was a blessing. Something about driving by the ocean on the way to work that makes life better, I have to say.
I was born in
No
Portland,
offense to our logging
Oh, were you?
inland folk.
and that's about all I could say. After that,
Crescent Beach. Yeah.
it was all visitation after that.
Crescent Beach Park was my stomping grounds when I was growing up in South Portland.
I used to cross-country ski in that park in Crescent Beach, long time ago. I'd fall over in my tracks right now if I tried.
It would be hard right now too, because there's not a whole lot of snow over there.
Yeah, there'd be that. Cross-country skiing on grass and sand is not so good.
It looks like we have a quorum and most of the committee members here, in fact, and we have our honored guest, the nominee, Judge Mullen. And so I think we'll begin our committee meeting. Also, we are live streaming on YouTube now. I want to let members of the public know that today we'll have a series of hearings on judicial nominations, starting with the Honorable Robert Mullen, who serves as the Chief Judge of the Maine Superior Court. We typically begin our committee meetings with committee member introductions, and so we'll do that in a moment. And we also want to welcome our newest committee member, Representative Jim Thorne. And with that, I'm going to just call on committee members for introductions, and we'll start with Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Northern Oxford County, the beautiful Western Maine Mountain region. And welcome.
Thank you. Representative Babbage?
Yes, thank you, Madam Chair. My name is Christopher Babbage. I represent House District 8, having the privilege to represent the good people of Kennebunk.
Thank you. Representative Reckett?
Yes, my name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thanks. And Representative Moriarty?
Good morning, all. I'm Steve Moriarty, representing part of Gray and my hometown of Cumberland, which noted its bicentennial this past Friday.
Nice. Then Representative Sheehan?
Thanks, Madam Chair, and welcome, everyone. My name is Erin Sheehan, and I'm proud to represent Biddeford, House District 12.
Thank you. And Representative Thorne?
Good morning. Technical difficulties. Just wanted to make sure my my mute button was off. My name is Representative Jim Thorne. I represent Carmel, District 103.
Thank you. And welcome again to the committee. Next, Representative Libby?
Thank you. I'm Laura Libby, and I live in Auburn. I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Poirier?
Thank you, Madam Chair, and good morning, everyone. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thanks. And Representative Evangelos?
Morning, everyone. Welcome. Representative Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you. And Representative Harnett?
Thank you, Madam Chair, and good morning and welcome, everyone. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Senator Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I'll be chairing the first two hearings this morning, and then Representative Harnett will chair those in the afternoon. And at this point, we're going to start with the confirmation hearing for the Honorable Robert E. Mullen. And we do have a script that we're required to follow, and so that is where we'll begin. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Robert E. Mullen of Norridgewock for reappointment as a Superior Court Justice. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by a majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice to the committee of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after today's nomination hearings are concluded. We'll turn now to the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes co-chair Tom Harnett for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Robert E. Mullen of Norridgewock for reappointment as the Superior Court Justice.
Thank you. Representative Sheehan?
Thanks, Madam Chair. I second the motion.
Thank you. Now we'll turn to the position and legal requirements for the nominee. A copy of the statutory requirements for this position is available at the rostrum and also online for those who would like to view it. I do want to just take a moment to welcome again Justice Mullen to the proceedings, and we will begin with the governor or her representative. The chair now recognizes Jerry Reed for the purpose of making a statement concerning this nomination.
Thank you. Good morning, Senator Carney, Representative Arnett, members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills. I'm here this morning to speak in support of the nomination of the Honorable Robert E. Mullen of Norwich Walk for reappointment as a Justice of the Maine Superior Court. Chief Justice Mullen is a graduate of the University of Maine at Orono with a degree in psychology and earned his law degree at the University of Maine School of Law. He's dedicated his life to Maine's justice system. After graduating from law school, he spent the following 17 years working at the firm of Linnell, Choate, and Weber in Auburn as a general practitioner, handling cases arising in a wide range of subject areas. In 1996, he was appointed to the District Court by Governor King. He served there until 2014, when he was elevated to the Superior Court by Governor LePage. During his time on the Superior Court, he has served primarily in Kennebec, Somerset, and Franklin counties. He was named Deputy Chief Justice of the Superior Court in 2016, and in January of 2020, he became Chief Justice of the Maine Superior Court. In that capacity, he capably led the Superior Court's response to the many and time-sensitive challenges that the COVID-19 pandemic has presented. Chief Justice Mullen has earned the respect of his colleagues, the Maine Bar, and the litigants who appear before him. He has been steadfast in his commitment to fair and effective administration of justice for Maine's people. On behalf of Governor Mills, it's my pleasure to ask for your support for the nomination of the Honorable Robert E. Mullen of Norwich Walk for reappointment to the Maine Superior Court. I'd be happy to answer any questions that you may have at this time.
Thank you very much, Mr. Reed. Committee members, are there questions for Mr. Reed? Representative Babbage, you may proceed.
Thank you, Madam Chair. Mr. Reed, good to see you again. Jerry, I had a question. This nominee is absolutely superlative, but in the process of vetting, one of the questions on the questionnaires came to my attention. I wanted to ask you this. Not only in the original vetting, but even in renomination, do you check the financial health of the nominees?
We do not do an in-depth investigation into the financial background of the nominees unless there's something irregular that presents itself during the course of the process. So there are, as you're observing, there are a number of questions that get at the financial circumstances of the nominees. And in the course of reviewing those responses, we make an assessment about whether any further investigation is warranted, but it's not routine for us to do that sort of investigation in the absence of some indication that that's warranted.
Thank you. I know the question said, if asked, would you be willing to share your tax returns, that kind of thing. That's not normal, but it is there in case something is flagged. That's right. That's right. Thank you very much. Appreciate it. Thank you, Madam Chair.
Are there other questions by committee members? Not seeing any questions at this time. I would just like to pause for a moment and allow Senator Heather Sanborn to introduce herself.
Thank you, Senator Carney. Good morning, everyone. My name is Heather Sanborn. I represent District 28, which is half of Portland and half of Westbrook, and I'll be doing double duty today, serving on another committee as well.
Welcome, Senator Sanborn. The chair now recognizes the Honorable Robert E. Mullen for the purpose of making a statement concerning this nomination. Welcome, Justice Mullen, and you may proceed.
Senator Carney, are you going to want to hear from the Judicial Selection Committee?
I was, Mr. Hobson, and I wasn't remembering whether you spoke initially right after Mr. Reed or if you were the first speaker after Justice Mullen. Would you like to go now?
Yes, the practice, at least for the past, I don't know, number of years, has been to have the Governor's Council go, and then the Judicial Selection Committee, and then the nominee.
Yes, and it wasn't in my script, and I wasn't remembering, and so I got it wrong. But you may proceed.
Thank you very much, Senator Carney, Representative Harnett. My name is John Hobson, and members of the Joint Standing Committee. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee, and I am here on behalf of the Judicial Selection Committee to support the reappointment of Justice Robert Mullen to the Maine Superior Court. Justice Mullen has a long history of involvement in the judicial branch, which you can see from his questionnaire. What stands out to the committee for Justice Mullen is really his ability to do both the tasks of a Superior Court in an exceptional manner and also do the functions, the administrative functions. He has been an administrative function as chief judge of both the district court and then when he was elevated to the Superior Court, to the Superior Court. And as this committee probably gathers, every judge who is appointed to the bench is separately appointed by the governor, separately nominated by the governor, separately confirmed by the legislature. And so they each come to the job with a fair amount of independence. And the old saying that sometimes doing administrative duties for a number of kind of independent type personalities is like herding cats. That's certainly true in the judicial branch, especially with the wide number of geographic areas that this state covers and the courthouses throughout those areas. Justice Mullen, and what impressed the committee is that Justice Mullen is able to do the job that he does as a Superior Court justice, again, excellently. But he brings to the administrative side, and you may get this from his remarks, and his demeanor is one of very calm, kind of understanding, and yet firm. And so that he's able to both bring his courtroom demeanor to the litigants and control the courtroom, but he also brings that same demeanor to his administrative duties, both kind of understanding the concerns of his colleagues who are on the bench, but also making sure that the wheels of justice continue to turn. And candidly, that's no small task in the current environment with COVID-19. And it's been the experience of Justice Mullen, both at the district court level, as an administrative, as part of the administration of the judicial branch, and now as a Superior Court, that really makes him kind of one of the unsung heroes of keeping the judicial branch going and making sure that the citizens of the state of Maine are able to get justice in a timely manner and in a manner in which represents the state well and basically does the job for the citizens, both in dispensing justice and in treating its citizens fairly. And so with all those qualities, the committee would very much support this committee taking a favorable vote on the reappointment of Justice Mullen.
Thank you very much, Mr. Hobson. Committee members, are there any questions for Mr. Hobson? I am not seeing any. Thank you. And thank you for reminding me about the sequence of speakers. I appreciate that. And at this time, the chair now recognizes the Honorable Robert E. Mullen for the purpose of making a statement concerning his nomination. Welcome.
Thank you. Good morning, Senator and Chairperson Carney, Representative and Chairperson Harnett, and distinguished members of the Judiciary Committee. My name is Bob Mullen, and it's my distinct pleasure and honor to be given the opportunity to speak to you concerning my request to be reappointed as a Superior Court Justice for the state of Maine. I want to thank Governor's Chief Counsel, Attorney Reed, and Attorney Hobson for their kind introduction. Thank you. And Senator Carney, you might have seen on my copy of my written testimony, I kind of hedged my bet because it wasn't clear to me either exactly the sequence when someone speaks. So certainly don't have to say anything about that for me, for my sake anyway. I first became a judge for the state of Maine in August of 1996 after being nominated by Governor King and being confirmed by the Judiciary Committee and the Senate to become a district court judge. I was fortunate enough to be reappointed in 2003 and again in 2010 as a district court judge. I had the opportunity to serve as a deputy chief judge of the district court for first Chief Judge Vendine Vafiades and later for Chief Judge Charles Laverdia. I want to thank them for their confidence in me and for giving me the privilege to serve as their deputy. I also want to thank Dean Lee Softly for the privilege of working for her in her administration when she was Chief Justice of the Maine Supreme Judicial Court, along with the trial chiefs of the Superior Court at the time, first Chief Justice Nancy Mills, and then Chief Justice Thomas Humphrey. They have huge shoes to fill. I also want to thank Ted Glessner, State Court Administrator, for his steady guiding hand that's been present ever since I went on the bench back in 1996. More recently, I was appointed to the Superior Court bench in April of 2014. Eventually served as Chief Justice Roland Cole's deputy for 3.5 years until he retired, and I became the Chief Justice of the Superior Court at the beginning of 2020. I grew up just down the road in Farmingdale, graduated from Halldale High School, still consider myself a proud Halldale Bulldog, and I'm a graduate from the University of Maine at Orono in 1976 and from the University of Maine School of Law in 1979. I live in Norwich Walk with my wife, Holly, and my in-laws, Fred and Donna Foss, who live right down below us. We live in a condominium association in Norwich Walk. It seems more like 7 months ago rather than 7 years ago that I was before this committee seeking to become a Superior Court Justice. But candidly, the last 12 months sometimes have seemed more like 12 years. So I think things do perhaps balance out as they sometimes do in life. As I said 7 years ago, I still look forward to going to work every day. I recognize the privilege and confidence four governors have placed in me by providing me the opportunity to serve as a judge in Maine and hope to continue in my position as long as people will have me. I could talk about the challenges that we've all been presented in the last 12 months, but I'd prefer to talk about what the future holds for us. We've all had unprecedented challenges over the past year, both professionally and personally, but I truly believe that the proverbial light is at the end of the tunnel, and we are going to come out of this pandemic stronger and smarter than when we entered it. We are indeed all in this together, and I cannot exaggerate the feelings of pride that I have almost every day concerning how the judicial branch and the Maine bar has handled the unique challenges that pandemic has posed. Yes, we got knocked down a few times, but we got right back up and have more than held our own in this battle that has lasted way too long. But again, I believe the light is at the end of the tunnel. As I assured this committee 7 years ago, I assure you that I'll do my very best to continue to effectively serve the citizens of this state. If you see fit to support my renomination to the Superior Court, I'm confident that I'll be able to perform my duties as a Superior Court Justice at a level of competency such that you will, if you support my renomination, be able to look back when you're in the future, look back anyway, at your support for my renomination with satisfaction, not regret. I promise not to let you, much less the people of Maine, down. In closing, I want to thank you all again for the opportunity to address you concerning my renomination, and I'm happy to answer any questions you might have of me. But before I do that, I want to recognize some people in my life. My two sons, Matt and Sam, and Matt's wife, Emily, as well as Sam's fiance, Liz. My granddaughter, Sophie, who's going to be 3 next month and is already more than a match for her grandfather. My stepchildren, Spencer and Brandy, and my sisters, Sandra and Jeannie. And Jeannie, if you're listening, I've said Sandra first, not because she's the oldest, not because she's the favorite. And finally, last but not least, my lovely wife, Holly, who's at work, but is here in spirit. I love all of you very much. Thank you, and I'll be happy to try to answer whatever questions you might have of me.
Thank you very much, Justice Mullen. Members of the committee, are there any questions? Go ahead, Representative Babbage, you may proceed.
Thank you, Madam Chair. Justice Mullins, it's great to meet you.
Nice meeting you, sir.
Very impressive resume and references. Looking at your background and seeing your time in the district court and then as an administrator and on the Superior Court and Chief Justice of the Superior Court, I wondered if you'd actually taken on perhaps the most challenging assignment in being a member of your condo board.
It's ironic that you bring that up because when we moved there in November of 2018, the president and the treasurer, who were husband and wife, announced that they were retiring from those roles, and they had served there for a long time, for umpteen years. So it was certainly understandable. And I have to admit, I was kind of half hoping that maybe I'd have some type of ethical conflict or something that I couldn't do it, but I did not. And I was a logical choice. So my father-in-law, myself, and the gentleman right across the hall from him, with the board of directors, we just met last 2 weeks ago on Sunday, to have our annual meeting. We have different things that come up. Right now, we're looking at a roof that we need to replace, and it's an interesting challenge. But actually, I like everybody very much who's in there. They're all good neighbors. About the most challenging thing we had to do is our neighbors downstairs, right down below us, asked me not too long ago, the gentleman who used to be the president said, "Gee, what's going on?" And I go, "I'm not sure what you mean." He goes, "Geez, your TV's kind of loud." And I thought, well, it's never been loud, but I didn't want to argue with him. So we got something called TV ears. And so now I'm wondering if he thinks that we've just go to bed at 6 o'clock at night because we put our TV ears on. And it's just silence, but we hear just fine. And my wife can turn them up as loud as she wants, and I can turn mine up or down. And so if that's the biggest challenge I have faced so far, then
Well, I asked tongue in cheek, of course, but my wife was, the motivator to get us into a condo. I think I don't know if she's thinking of end of life considerations here or something, but my point was that it's funny what life goes, because a lot of people go to a condo to avoid maintenance responsibilities, and now I'm responsible for 56 units instead of my own home. So, but I find that it is a challenge. It is a challenge sometimes to, I'm not sure in Superior Court if it's the same, but as in district court, but making important decisions among a small community of neighbors is the experience that I'm talking about. So anyway, thank you so much for agreeing to continue to serve, and we appreciate your contribution very much.
Appreciate that. Thank you. I only have 10 units to worry about, so you've got a much bigger challenge than I do.
Representative Evangelos, you were next with a question. You can proceed.
Thank you, Madam Chair. Good morning, Justice Mullen. Hard to believe 7 years have gone by.
I know.
I only have one question. I want you to do me a favor tonight. My question and request is, when you get home, would you thank your wife for the exemplary job she's doing to help legislators through this difficult session? She's doing just an awesome job under the most difficult circumstances. So you pass that along for me?
I certainly will. And I'm certainly sure that she's going to appreciate that.
That's all I have.
Thank you. And Representative Reckitt?
Yes, as one sec till I lower my hand. It's something about it. Judge Mullen, as we reminisced momentarily ago about the day that you likely don't remember or know that it was my 50th high school reunion, at which we had a conversation that conjured up the first real training in an organized way, in my view, for the bail commissioners in Maine. And I was appreciative of your willingness to step out on that limb with me at the time. I was not part of the judicial branch. I just had a scheme. And I have a two-part question. Is there still work to be done in training bail commissioners, in your view, since you have a long view of it, as do I? But the other piece of the question, which may or may not be connected to the first, is there's been discussion for a long time about whether or not bail commissioners should be part of the judicial branch and control employees of the judicial branch, and not taking their fees directly, but those to the judiciary. Do you have an opinion on that? And the other part of the question is, how are we doing with bail commissioners these days? Do you still have any interaction with them in the Superior Court? Probably not, right?
A bit. First of all, I want to assure your committee members that I wouldn't say you had a scheme. I would say you had a great plan that kind of ran with. And I remember that, yeah, I was kind of, quote, placed in charge of the bail commissioners at some point, I think, either before or shortly after I was first tour of duty as deputy on the district court. And I think they've come a long ways. And believe me, whatever efforts I made to improve the quality of the bail commissioners are dwarfed by Ann Jordan, because she took it over. And I have to say, it's one of the things I still remember when I was told I don't have to be quote in charge of the bail commissioners anymore because Ann Jordan's going to do it. And she's been great, and she gets rave reviews from all of them. I think she's lifted up the standards for training. She's organized it. She's tireless. She's just a great source of assistance to a lot of people in the criminal field, in the courts. I'm not as up as I used to be on what their training is, but I'm sure it's if it's anything like it has been right along, it's rigorous. I think not that we didn't have good bail commissioners back in the early 2000s, but I think they're even better now. I think they take their jobs incredibly seriously. We used to get some complaints that would bubble up, to the trial court or the clerk's office from time to time. As far as I'm concerned, they're almost noticeable now because they're so rare that when there is a complaint, it's noticeable because you just don't get complaints anymore about them. Would it be a good idea if they were members of the judicial branch? Yeah, my personal opinion would be yes, absolutely. The issue, as always, is funding. Right now, they're basically independent contractors, and other than paying for training, to the extent that members of the committee may not know this, I mean, they're paid by defendants. Who, although if they're indigent, then the bail commissioners waive their fees, and way back when, I mean, so far back that it's almost silly for me to bring up, but from time to time, you'd hear complaints about, oh, the bail commissioner, set a high bail because they weren't going to get paid or something. That's been almost eradicated as far as I'm concerned years ago. They come in, they set the bail, they execute the bail, they go over the bail terms, and they do so at all hours of the day and night. And there's been suggestions that a fund should be set up so that they get paid irrespective, so they don't have to rely on defendants' payments. And that would just eliminate even the hint of any type of conflict. But again, it comes back to money. And so right now, I don't know of any, there's been some discussion about that in years past about trying to set up funds. I know jails, I think jails are authorized still to have certain funds to try to pay bail commissioners, but to my knowledge, I know Kennebec did it for a while. I'm not even sure if any others have done it. But it's another example of the system doing more with less, or basically less in this case is sometimes they get paid and sometimes they don't. So yeah, it would be, I'm sorry, I'm being so long-winded. Would it be a good idea to have them employees of the judicial branch? Absolutely. I know back when there was a sentencing commission, I think it came up, there was a discussion about why don't we go to the magistrate system in Virginia? And the cost was back then, for $1 million, we could do that. Well, we didn't have $1 million then. I don't think we have $1 million now. And that was 15 odd years ago, probably close to 20. So $1 million would be who knows what's now. So to answer your question, yes, they need training. I think they get the training. I think Ann is very good about updating the training as different issues come up. In an ideal world, I would absolutely love them to be employees of the judicial branch, or at a minimum, have them paid from a separate fund. So you just eliminate the defendant's financial abilities or lack of same, just right out of the equation. But I think they do a wonderful job, and I'm a big supporter.
Thank you.
Thank you very much. Committee members, I know that, I see that Representative Evangelos has another question. You may proceed, Representative Evangelos.
Thank you, Madam Chair. Justice Mullen, reading over your material, I recognize you're the Chief Justice of the Superior Court, and consequently, I want you to pass on a request that all of the Superior Court justices take into consideration the deficiencies of our Sixth Amendment situation outlined in the Sixth Amendment Center report. The Indigent Legal Commission and the Judiciary Committee is grappling with making significant improvements, but I'm starting to hear and read about some disturbing information that it's not going to be included in a budget document. So our reforms may not take hold. So if that's the case, our justices are our last line of defense. So I just put this request in. I guess I'll try to frame it as a question. Will you please make sure all of our Superior Court justices are keenly aware of what's going on with the Sixth Amendment Center report, and assure me that our indigent legal defendants are going to get the right to effective legal counsel and a fair trial. Thank you.
I certainly will, Representative, and I can tell you that everybody, and when I say everybody, all the judges got a copy when it first came out. It has been supplied again after the series of articles in the Main Monitor by Samantha Hogan came out. And it's something that people grapple with every day. I mean, the bar grapples with it every day. That's one of the one of the reasons why I wanted to thank them right up front, because it just, this pandemic just made things really challenging. But I think the Maine bar has stepped up. The Sixth Amendment Center made some good points. We'll wait and see how we're going to get, how McGillis is going to get budgeted. Sometimes I wish I was in the legislature, but then when I see all the need, the financial needs and the programs, and then how people divvy up the money, then I kind of my interest wanes, because I just think it's a really difficult, challenging task. And anytime I think I have a tough job, I can think, other people in state government have tough jobs, certainly starting in the legislature and on the appropriations committee. So it'll be interesting to see how this all works out.
Thank you.
Thank you. Representative Moriarty, you had your hand raised previously. Do you still have a question?
Thank you, Madam Chair. I did have it raised and somehow it was cut out of the transmission and had to log on again. I just wanted to say a personal hello to Judge Mullen. I am also a former Halldale Bulldog, although we didn't overlap at that stage. We knew each other in law school. That's been a long time, Bob. So good to see you again this morning. I just wanted to note that this is your 5th consecutive nomination to the bench. And you have, I think, what could be a unique distinction of having been nominated by chief executives of the 2 major parties and an independent as well. And I think that speaks volumes about your capabilities and expertise as a judge and a justice. So congratulations on this most recent nomination.
Thank you very much. I appreciate that.
And we've been joined by Representative Newell. Representative Newell, would you like to introduce yourself?
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I'm the Passamaquoddy Tribal Representative. Please excuse me for arriving late. I was representing in Marine Resources. However, I have been listening in on the YouTube channel. So please excuse me.
Welcome, Representative Newell.
Thank you.
And Representative Babbitt, did you have another question? We're not able to hear you.
Thank you very much, Madam Chair, for mentioning that. I just wanted to give the Justice an opportunity, if he would, to comment on his experience as being a chair of the pretrial Justice Reform Task Force, and if he wanted to leave any messages regarding that with this committee.
Thank you for the opportunity to do that. Then Chief Justice Softly made me chair of the task force back in 2015, I think it was when we first got together. Met a lot of people from, so-called stakeholders who it was great to meet and great to get different people's perspectives. We came up with a list of recommendations, and I think, if memory serves me, every recommendation that didn't have a fiscal note was adopted by the legislature. And there were some recommendations that the judicial branch also adopted. And the ones that weren't, I'm not saying everyone was fantastic. I thought they were, but obviously reasonable minds can differ. But the ones that didn't get passed had a fiscal note. And that kind of confirmed for me, or just reminded me how difficult the budgeting process is. And then more recently, we came back with another. The chief reconstituted the group, and we focused mainly on data and just how difficult it is to come up with data to either support or show that a particular thought is just not supported by the evidence. And I think our CMS system is going to go a long ways towards solving some of those challenges. I mean, for example, I think I'm right on if we, for example, want to find out what the grounds are for a violation of conditions of release, because there's a lot of people who are in jail because they are charged with violation of conditions of release. Wouldn't it be nice to know what the grounds are? And that, unfortunately, I'm pretty sure I'm right on this. The only way we can do that is if we do a hand count, manual check of all the files on violation of conditions of release, what the grounds are in the complaint. And so, I mean, that's just a very small nugget of the type of information that I think I may be oversimplifying it, but I think, at a push of a button, we're going to have that answer in minutes, if not seconds, versus just way too much labor intensive required to come up with the answers like that. So we'll see. I'm encouraged. I'm encouraged, and unfortunately or fortunately, depending on your point of view, I've been around for quite a while, so I can remember back where we first got laptops a few months after I first started in 1996. And I can remember, when PA, protection from abuse orders, were not on the so-called switch, so that police who, got a call after 4 o'clock on a Friday till Monday at 8, they didn't know if a PA was in effect or not. And so it seemed crazy that was reality, but that was the reality. But people like Lois Reckitt and others, we were able to put together a system, and now it's just assumed that 24 hours a day we know what the status is of things like that. And there's countless examples of that you could come up with. And so we have made dramatic changes, but it's incremental and it's not as fast as we all want. But I think we're getting there, and I know I'm proud. I'm proud of the system. Love the job, and I think we're just going to get better. That's all.
Thank you very much, Chief Justice Mullen. Committee members, are there any additional questions for the nominee? All right, thank you. Thank you, everyone. The chair will now take comments from the persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted a statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to a panelist status in the electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members, you will be returned to the attendee status and the next person will be called. I will now recognize the persons who wish to testify, and we will start with Lee Softly, who has already appeared as part of our panel. Welcome, Lee, and you may proceed.
Thank you very much. Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Lee Ingalls Softly, and I am from Cumberland County. And I want to be clear this morning that I do not represent or speak for the University of Maine system or Maine law. I appear today in my capacity as an individual who worked for decades with Chief Justice Robert E. Mullen. I've never been able to testify on a matter related to a judgeship before, and I take this opportunity very seriously. I want to begin by thanking John Hobson, who has worked on judicial nominations, which is a thankless job, for more years than I can count. The entire state of Maine has benefited from his very thoughtful public service. Thank you, John. It is an honor to appear before you today in support of the nomination of Robert E. Mullen to another term on the Superior Court. Maine has a solid history of a nonpartisan process for the appointment of judges, and we should all be very proud of this system. The governors and their nomination committees work hard to find the right people. This legislative committee and the Senate take their responsibilities very seriously. The result is a judiciary comprising smart, hardworking, and ethical judges. With reappointment review at reasonable 7-year intervals, I believe that Maine has the best system of judicial selection in the country. Although every 7 years, I thought that Maine should go to lifetime appointments. I think I should just disclose that here this morning. Regarding Bob Mullen, you've heard the details of his long public service on the bench, and you know he has served in multiple occasions in judicial leadership, and there's a reason for that. Being a deputy or chief judge or justice in Maine's trial courts is a very challenging job. It carries all the responsibilities of a sitting judge and another full-time job. It requires juggling many administrative matters, watching budgets, supporting judges who are ill or who have broken a leg, covering schedules, communicating with constituencies, and responding to constant change. And today, as you have already noted, it requires grappling with a global pandemic. The need to balance access to justice with the safety of the public, the bar, court staff, and judges requires a finely honed sense of priorities and an ability to work in times when you simply cannot take care of every challenge. It requires patience, compassion, and an ability to focus on the needs of the public, even when the distractions are overwhelming. Bob Mullen is a judge who brings all of that to judicial leadership. He's a judge who would drive through the night to be at the bedside of an injured judge, a judge who spent hours working on committees and working groups to make the judicial branch more responsive to the public, including that bail commissioner system, a judge who takes the time to talk with distressed and sometimes angry litigants who didn't understand the process. He's also a judge who has dealt compassionately with other judges who have struggled to handle the caseload or the stresses of the job. And again, he does so with kindness, but always with an eye to protecting the public. And selfishly, I can say he was always willing to take the midnight phone calls from other chiefs when necessary. Through all of the demands, the lost family weekends, the long nights of budget analysis, Bob Mullen never lost his patience, his sense of humor, or his absolute dedication to putting the needs of the public first. I fully support the reappointment of Robert E. Mullen to the Superior Court. I thank you for your time and your service to the people of the state of Maine, and I'd be pleased to answer any questions.
Thank you very much. Committee members, are there any questions? Not seeing any hands raised. Thank you very much for speaking on behalf of the nominee today.
Good to see you.
Good to see you too. And the The next member of the public speaking on behalf of the nominee is Roland Cole, and he has joined the panel. Justice Cole, you can proceed whenever you're ready. For those who are watching, the transition from being an attendee to a panelist sometimes takes a couple of minutes, but I think we'll be ready in a moment.
It says my microphone is unmuted.
We can hear you very well.
Are you able to
activate your camera as well?
And that I'm having problems. Let me see here.
Okay. If not, you can just proceed with the audio.
All right. Well, that's probably preferable for most of the panelists there and members. I'm a resident of Wells, Maine. I'm an active retired judge. I was involved when Tom Humphrey was appointed to an associate justice of the Supreme Court. He had been chief judge of the Superior Court for over 10 years. When Chief Justice Softly at that time asked me to serve as chief, I said that I would do so on an interim basis because I knew there were a lot of projects in the judiciary that would take planning. And I didn't intend to be working for as many years as to carry out the terms of that plan, and specifically the Odyssey case management and e-filing systems were being projected. We were working on those, and so I asked to have a deputy appointed. We had some applications, and it was not a difficult decision for us to go ahead, and I recommended, and Chief Justice Softly appointed him as the deputy chief. I had not worked a lot with Bob before that. As a trial judge, he had tried cases in front of me, both civil and criminal, and I had worked with him in regard to some committees since as a district court judge, but in the Superior Court, he was fairly new. He picked it up, the work very quickly, and he has a unique ability to get along with everybody. He's a great communicator, but he's also can carry out, he can facilitate the project. I apologize, but apparently there's an alarm going off here in the background for the noise. So
we can hear it just fine.
Okay, well, I can hear it anyway. I note that the judges in the Superior Court goes from Aroostook to York, and they very much appreciate, especially with the COVID issues that have occurred, the constant communication that he has, listening to their problems and trying to come up with solutions. It's been a thankless job. I got done, submitted my resignation as of January 1, 2020. Well-timed, I would say, in view of what's taken place since then. And but to know how the system works primarily because of the interrelationship of the judges and the clerks. And so I've been sitting as an active retired judge and able to successfully use Zoom, apparently better than I am this process here, and work with the clerks in several of the courts around the state over the last 9 months or so. And I can tell you the clerks are very appreciative of Justice Mullen, his communication, his support for them under very difficult times. And I think I can speak on their behalf that they would wholeheartedly support his nomination, as do I. Thank you. I will be happy to answer any questions.
Thank you very much, Justice Cole. Are there questions from committee members? Not seeing any. Thank you very much for speaking with us this morning. Next, we will turn to Kelly McDonald, who is appearing on our panel momentarily. Welcome, Mr. McDonald. You can proceed whenever you're ready.
Thank you so much. Good morning, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Kelly McDonald. I'm a resident of Portland, Maine. I'm a lawyer at Murray, Plum & Murray here in Portland, and I am currently serving as the president of the Maine State Bar Association. I am pleased and grateful for the opportunity to speak today in support of Justice Mullen's nomination. As the members of this committee are aware, whenever a judge has entered the 6th year of their term, we send out surveys to all of our members asking for feedback and comments on that judge's tenure on the bench. We have done so in this instance, and I would like to share some of the feedback that we received from our members about Justice Mullen. Our members who responded to the survey described Justice Mullen as compassionate and courteous to all who appear before him. He has a down-to-earth and approachable demeanor, which makes lawyers and litigants feel welcome in his courtroom. Justice Mullen is described as sharp, insightful, fair, well-prepared, and thoughtful in his decisions. He is commended for his ability to run an efficient and controlled courtroom. All of these positive accolades have earned Justice Mullen the support and respect of the members of the Bar Association of the Lawyers in Maine. We believe that Maine citizens will benefit from Justice Mullen's continued service on the Maine Superior Court. And I would personally like to thank Justice Mullen for his efforts as Chief Justice of the Superior Court. That's a lot of extra work this year, and we appreciate all of his efforts. So that's what I have to report to you from the lawyers who practice in front of Justice Mullen. I would be happy to answer any questions the committee might have. Thank you.
Thank you very much. Committee members, are there any questions for Mr. McDonald? I'm not seeing any. Thank you for appearing before the committee today.
Thank you.
And next we'll hear from Jason Jabber, who has appeared on our screen, and you may proceed whenever you're ready, Mr. Jabber. We're not able to hear you.
Sorry about that. Good morning, Senator Carney, Representative Harnett, and the Judiciary Committee members. My name is Jason Jabber, and I'm the treasurer of the Maine Trial Lawyers Association. I'm a practicing lawyer with offices in Waterville and Portland. On behalf of the Maine Trial Lawyers Association, I'm here to speak in support of Justice Mullen's renomination to the Maine Superior Court. We surveyed our membership regarding Justice Mullen's experience, temperament, skill, and ethics. Our executive committee reviews these results and adds these experiences into the process. The testimony today is meant to reflect a consensus of this process. Our association's survey members overwhelmingly rated Justice Mullen highly for his experience, temperament, skill, and judicial demeanor. These evaluations are not surprising, as our members rated Justice Mullen highly in previous surveys. In assessing these surveys, our executive committee noted his almost 25 years of judicial experience, as well as 17 years in private practice. He has demonstrated exceptional leadership skills at all levels of judicial service, rising to Chief Judge and Chief Justice, respectively, at the district and superior court levels. The executive committee particularly appreciates his leadership during the pandemic and his efforts to keep the courts operating safely. Based on the high evaluations of our members, his extensive experience, and his demonstrated leadership skills, I am proud to endorse Justice Mullen's renomination to the Maine Superior Court on behalf of the Maine Trial Lawyers Association. I want to add that from on a personal level, I also want to express my enthusiastic support for his renomination. I've appeared before Justice Mullen on several matters, both civil and criminal, in district and superior court. And I found that it was fitting that Attorney Hobson spoke about his calmness. And there are a couple of examples that come to mind when thinking about his calm demeanor. The first is, and I don't know if he's still a basketball referee, but he was a basketball referee for a number of years. And I've seen him refereeing high school games and youth games. And also I used to play men's league basketball, and he would occasionally ref those games. And you'll never see a bigger group of whiners than in a men's league basketball game. And in addition to being an excellent ref, his calm demeanor really helped to diffuse all the bickering and the whining and the complaining. And he was easily able to overcome that. The other example that comes to mind is more relevant to this, which is the experience I had with Judge Mullen in district court, presiding over what was probably one of the most hotly contested, bizarre family matters ever to go through Augusta District Court. And I'm sure he's sitting here remembering exactly the case that I'm talking about. There were several days of contested hearing, pre-trial hearings, post-trial hearings. It was the file that was never closed, and the clerks, I'm sure, remembered as well. And his calm demeanor was so important in that particular case, where the litigants, it was so emotional and, like I said, bizarre. And he very deftly and in an exceptional way presided over that trial, and ultimately rendered a fair decision in what was a complicated, difficult case. It gives us lawyers a great deal of confidence to go in front of a judge who is calm, courteous, practical, and most importantly, fair. And Justice Mullen has established a reputation for all of those things. So it's with great enthusiasm that I personally, and on behalf of the Maine Trial Lawyers Association, support his renomination to the Superior Court. I'll take any questions if there are any. Thank you.
Thank you very much. Committee members, are there any questions? And I'm not seeing any, so thank you very much for speaking with us this morning, Mr. Jabber.
Thank you.
And I just need to check and see if we have heard from everybody who spoke up, who signed up in advance to speak on behalf of the nominee. I know that there are several people who are still in the attendee space, and I would just ask anyone in the attendee space who is here to speak with regard to the nomination of Chief Justice Mullen to please raise your electronic hand so that we can bring you over onto the panel. And I'm not seeing anybody in the attendee space, so we will proceed. All public comments having been taken, the committee will now proceed as follows. We'll review any additional written comments on the nomination that have been received by the committee. And at this time, I'll call on our committee clerk, Susan Panett, and ask her if we have received any additional written comments during the course of the hearing this morning.
We have not, Madam Chair.
Thank you very much. The next step will be to vote on the nomination and notify the President of the Senate pursuant to Title III MRSA, Section 157, and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Robert E. Mullen of Norridgewock for reappointment as a Superior Court Justice is now closed. We'll proceed to taking of the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to take the vote immediately. Committee members, if you have an objection, could you either raise your electronic hand or wave your actual hand. And I scanned the committee members. I'm not seeing any hands. So there is no objection. The pending question before the committee is that the Joint Standing Committee on the Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Robert E. Mullen of Norridgewock for reappointment as a Superior Court Justice be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? Appears we are. The committee clerk will call the roll.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. 12 members voted in the affirmative, 0 in the negative, 2 are absent. That is the vote of the committee.
Thank you very much. 12 members of the committee having voted in the affirmative and no members of the committee having voted in the negative. It is the vote of the Joint Standing Committee on the Judiciary with the nomination of the Honorable Robert E. Mullen of Norridgewock for reappointment as a Superior Court Justice is confirmed. Congratulations, Justice Mullen.
Thank you very much. I appreciate it. I don't know what else to say. I just, actually, if I could have 30 seconds, I would say this. I want to thank everyone who spoke on my behalf. And I obviously appreciate the support of the committee. The one thing that I didn't get a chance to bring up, because I didn't see that an answer to any question that would fit, but we don't have enough marshals to open up every courthouse in this state on the same day. And we are closing courthouses to try to basically rob Peter to pay Paul so we can run dockets. And and I know you're the Judiciary Committee, I know you're not the Appropriations Committee, but if there's anything people can do to try to support any movement for us to hire marshals so we can safely run our court system. If you could do one thing, or if I could have one wish, that would be it, that we had bodies to open up all the courts and run all the dockets when we want to. And it's going to be more important than ever when we come out of this pandemic, and we are going to come out of it. So that's my public service announcement. And thank you all very much.
Thank you very much, Justice Mullen, and thanks for your reassurances at the beginning and at the close of today's hearing that there is light at the end of the tunnel. We really appreciate that. Typically, we would walk around the horseshoe and offer you handshakes and congratulations in person. Our substitute during the pandemic is a virtual round of applause, which the committee will give you now. And we do appreciate you and wish you well. Thank you very much. And committee members, we have another nomination hearing that will start at 11. I think we can take a little break before then. I see that Representative Evangelos has his hand raised. Representative Evangelos, do you want to ask a question?
Yeah, a couple. Thank you, Madam Chair. I think it's 11:30, so we've got 45 minutes. I'm not sure you can start the hearing a half an hour early. That's my first.
I think it was noticed for 11, but I'll check on that in the interim. Thank you.
My schedule says 11:30. Anyways, the second thing, and I don't care when we take this up, as long as we take it up this week, but it's imperative we take it up. You know, we worked long and hard on that budget. And from what I'm understanding, none of the reforms we met the Appropriations Committee with are included in this proposal. We're being forced to consider next week in a one-day session. So I'm very concerned that the work of our committee is being disenfranchised. I'm very concerned that none of the reforms we acted hard and long with the Indigent Legal Commission are even on the table. And it leads to a rhetorical question is, why do we even bother to serve and try to fix things? I think it's just an intolerable situation. So can we have a roundtable Judiciary Committee discussion on exactly what's going on? Because all I'm getting is rumors.
Yeah, I think we can definitely talk about it. I guess I don't share your perspective. I think the hard and valuable work that we did is still there as standing as a budget initiative. And as you know, we do supplemental budgets, and we've done them in the past, and we'll do them in the future. And so I still feel really confident about all of the hard work that we did last week. But we can certainly take that up perhaps on Thursday after our work session.
Well, I mean, I feel confident about the work we did. I don't feel confident that it's going to go into effect on July 1st.
Let's talk about it. I don't have any more information to share with you, but I can look into it more between now and Thursday after our work session.
Okay, so we'd be talking about it on Thursday after work session. Is that the intent?
Yep.
Okay, I want a firm commitment on that because I'll leave it at that. But
okay, yeah, I will definitely be available to talk with you, and I hope other committee members will as well.
Well, I don't want a one-on-one. I want a committee discussion.
I didn't mean to suggest that other committee members weren't going to be there. I was personally committing to you that I would be there, and I hope that other committee members will as well.
Okay, thank you.
Thank you. All right, everybody. We'll take a break until 11. And please, if you can remember to mute and stop your video, because the live streaming will continue even though the hearing is not continuing, and we'll pick things up at 11. And if you can return just a few minutes before, that would be helpful. Thanks, everyone.
Sure.
Yes, Representative Moriarty?
My schedule also shows the next hearing at 11:30. Are we allowed to start earlier, or?
I need to look into that. That was not my understanding. Let me see what was publicly noticed. And if.
Should we hold?
It looks like Representative Harnett may have some new information because his hand is raised. Go ahead.
Thank you, Madam Chair. I'm looking at the official notice that we received from the committee clerk this morning and last week. This has been noticed at 11 o'clock.
Thank you. And the committee clerk wants to weigh in as well.
Perhaps I can clarify. A very earlier weekly schedule went out with the incorrect date. It was changed to 11. Incorrect time. It was changed back to 11. So I apologize for that. I'm thinking perhaps you may be looking at an older version.
So
it is 11.
All right, see everyone at 11. Representative Thorne?
Is that the only change to the schedule at this time?
The hearings today are, the nomination hearings are at 11 for the Honorable Daniel Billings, at 1:30 for the Honorable Barbara Raimondi, and then at 3 o'clock for the Honorable Andrew Benson.
Thank you.
Sure, you're welcome. Any other questions? All right, see everyone in about 10 minutes. Thank you.
Hey, Judge.
John, it's been a long time. Good to see you.
Yes, good seeing you. Good seeing you. Hope you're making it through this pandemic world we live in.
Well, it's interesting.
Good morning, Justice Billings. How are you?
Good morning, Representative. I am fine. How about yourself?
I am fine, thank you. We're just waiting for committee members to get back, and we'll start the hearing up with Senator Carney arrives at 11 o'clock.
No problem.
So you have your pandemic beard, I see.
Well,
was it pre-pandemic?
Yes, we'll just say yes.
Okay.
It's recently trimmed.
I wish I could say the same.
Welcome, Justice Billings. I'm Ann Carney. It's very nice to meet you.
Nice to meet you as well.
We'll get started in just a few minutes.
How do you do, Justice Billings? Chris Babish, glad to meet you.
Good to meet you as well.
Hello, Justice Billings. My name is Representative Jim Thorne.
Good morning. Nice to meet you.
Nice meeting you.
Committee members, it is 11 o'clock and I think most of us are ready to start. And I see a couple of more videos turning on as we all gather back for the nomination hearing. All right, it looks like we can begin. Excuse me. Welcome, Justice Billings, to the Joint Standing Committee on the Judiciary. Welcome to those who are watching on the committee's YouTube channel. This is the public hearing of the Joint Standing Committee of the Judiciary for the purpose of considering the nomination by the governor of the Honorable Daniel I. Billings of Southport for reappointment as a Superior Court Justice. Under the law and the joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via the electronic format can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and is available to view on the committee's YouTube channel soon after today's meetings have concluded. We'll start with the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Lois Reckitt for the purpose of making such a motion.
I move that the Joint Standing Committee of Judiciary recommend confirmation of the Honorable Daniel I. Billings of Southport for reappointment as a Superior Court Justice.
Representative Sheehan?
Thank you, Madam Chair. I second the motion.
Thank you. A copy of the statutory requirements for this position is available online at the request of anyone who would like to see it. The chair now recognizes Jerry Reed, Chief Counsel for Governor Mills, for the purpose of making a statement concerning this nomination. Welcome, Mr. Reed. You may proceed.
Good morning. Thank you, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this morning to speak in support of the nomination of the Honorable Daniel Billings of Southport for reappointment as a Justice of the Maine Superior Court. Justice Billings is a magna cum laude graduate of the University of Southern Maine with a degree in political science and earned his law degree summa cum laude from the University of Maine School of Law. He began his legal career in private practice in central Maine, where the focus of his work for about 7 years was civil litigation and criminal defense. From 2011 to 2012, he worked as chief counsel to the governor. I worked with him in that capacity when I was in the Attorney General's office, and I knew him to be smart, honest, direct, and pragmatic. He was appointed to the Maine District Court in 2012 and was elevated to the Superior Court in 2014. During his term on the Superior Court, he has presided primarily in Knox, Lincoln, and Saginaw counties, while occasionally also presiding in York, Cumberland, Oxford, Androscoggin, Kennebec, Waldo, and Washington counties. While Justice Billings is completing just his first term on the Superior Court, he has already earned a reputation as one of the finest trial court judges in the state judiciary. On behalf of Governor Mills, I ask that you support the nomination of the Honorable Daniel Billings of Southport to a second term as a Justice of the Maine Superior Court. I'd be happy to answer any questions you may have of me at this point.
Thank you very much, Mr. Reed. Committee members, are there any questions for Mr. Reed? If so, please raise your virtual hand. Not seeing any questions for you, Mr. Reed. Thank you very much.
Thank you.
And at this point, we'll recognize John Hobson, who is the chair of the governor's nominating committee. Mr. Hobson, you may proceed.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee. On behalf of the Judicial Selection Committee, I urge this committee to act favorably on the reappointment of Justice Billings. Justice Billings, as Mr. Reed has said, is in his short time, his first term, has already become known as one of the best of the Maine Superior Court trial judges. And that's saying something because there are a lot of very, very good judges in the main trial system. And he's able to move the docket along and produce thoughtful and intellectually rigorous decisions. And there are two aspects of Justice Billings' reappointment that I think are of note. Back when I was on the committee when Justice Billings was then just Dan Billings and was applying, his background and his experience could have had him have a position immediately on the Superior Court. And during the course of the interview process, he applied for the district court. And during the course of the interview process, someone asked him, they said, why are you applying for the district court? You have so much experience in Superior Court and probably could very well get a position on the Superior Court. And his answer was important and enlightening, which was, he said, I think for my experience, to get the breadth of experience to be the best judge I can, that it would be helpful for me to see the district court, which is a people's court, and be a part of that court. And Justice Billings applied and was successful in becoming a district court judge, and very shortly became known as one of the best district court judges, even in that short period. That willingness to kind of basically do what it takes to become the best judge he could be is an important attribute in terms of someone's willingness to learn and be part of a system. The other aspect of Justice Billings' career, and is of note, is that when Justice Billings was first nominated to the bench, he had trial experience in private practice. He also had involvement in the political context, and there were some trial attorneys I knew who took, I guess, what I would call a wait and see attitude to see how then Judge Billings would do on the bench. And to an attorney, those attorneys who had expressed at least somewhat of a wait and see attitude have come back and said what a great appointment to the bench that Justice Billings has been, that he has been an absolute stalwart in terms of his intellectual rigor, in terms of his issuing decisions, his ability to move cases along, and that he is really one of the truly very good to excellent Superior Court trial judges. And so on behalf of the committee, I urge this committee to act favorably on the renomination of Justice Billings.
Thank you very much, Mr. Hobson. Committee members, are there any questions that you have for Mr. Hobson? I'm not seeing any hands. And again, thank you for speaking today on behalf of the nominee. The chair now recognizes the Honorable Daniel I. Billings for the purpose of making a statement concerning his nomination.
Thank you. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I am Dan Billings, and I appreciate this opportunity to speak with you this morning about my nomination for a second term as a justice of the Maine Superior Court. First, I would like to thank Governor Mills for the trust she has shown in me by nominating me for a second term. It is very much appreciated. Also, I'd like to thank Mr. Reed and Mr. Hobson for their very kind remarks. Second, I would like to thank the hardworking and underappreciated clerks and marshals of the judicial branch, without whom it would be impossible for judges to do our jobs. It is truly an honor to serve the people of Maine on Superior Court. Trial judges are entrusted with a great deal of authority and autonomy. The decisions we make on a daily basis have a critical impact on the lives of the parties before us and on the broader community as well. We must approach our work with respect, objectivity, compassion, and humility. I strive to meet that standard every day. Because only Representative Moriarty was a member of this committee during my last confirmation hearing, I thought I should tell you a little bit about my background. I was born in Gardner. I grew up in Bodenham and attended local public schools. During most of my childhood, my mother worked in a shoe shop and my father in a hardware store. I worked full-time while attending the University of Southern Maine, and after 4 years there, became the first member of my family to graduate from college. My path to the law was not a direct one. I had two undergraduate professors who were lawyers who encouraged me to attend law school, but I always hated school, and another 3 years of school at the age of 22 seemed like a fate worse than death. So I moved on into the work world, and I had various jobs over the next 10 years, including working in radio, managing now Senator Bennett's 1994 campaign for Congress, working for the legislature for a year, and running a trade association for 4.5 years. After 10 years in the workforce, at a more mature age of 32, law school looked more appealing, and I enrolled in the University of Maine School of Law in 2000. As it turned out, it was the first educational experience that I truly enjoyed, and I graduated second in my class in 2003. After law school, I practiced at Martin, Dubord, Bernier and Stevens in Waterville, where I focused on civil litigation and criminal defense. In 2011, I went to work as chief legal counsel for Governor LePage, and after 20 months in that very challenging role, he nominated me to the district court in September 2012. After a year and a half on district court, I moved to Superior Court in April 2014 and have sat primarily in Region 6, which is made up of Saginaw, Lincoln, Knox, and Waldo counties ever since. In some ways, it's hard to believe that 7 years have passed since I was last before this committee, but for me, much has changed over the last 7 years. In 2014, I was single. Today, I'm in a committed relationship with Brian Martin, who is a family law magistrate of the Maine District Court. We have two bright and lively daughters, Scout, who is 10, and Lily, who is 4. They keep us very busy and provide important perspective for the challenging work that we both do. In 2014, I was still in my 40s. Today, I'm in my early 50s. In 2014, I had less gray hair and was clean shaven. Today, I have a beard. But more importantly, in 2014, I was seeking the job that I've now been doing for 7 years, and which I hope you will allow me to continue to do for the next 7 years. I found it more challenging to prepare remarks for this hearing than for my previous confirmation hearings. It's somehow easier to put together arguments for why you are qualified for a job that you are seeking than to explain why you should keep a job that you already have. And frankly, it may be that I'm now years away from being an advocate, and I was closer to my work of advocacy when I was last before the committee. I'd like to think that I do my job well, but there are a few objective metrics that a trial judge can point to support that contention. By the nature of our jobs, we often upset as many people as we please with our decisions. Sometimes nobody involved with a case is happy with a judge. And other than an occasional law court opinion, we get little direct feedback on our work. I believe one of my strengths as a judge is my practical approach to cases. While I enjoy the challenge of a technical legal argument, my work on a daily basis usually involves more real-world concerns. I think another strength is my ability to explain the law and the process to people who appear before me, both parties and jurors. People often misunderstand the actual issues the court will be deciding and have no understanding of the judicial process. I believe I have ability to explain legal concepts and procedures in plain language that people can understand. One strength I know I have is the ability to move my docket. When I trained for district court, then Chief Judge Laverdiere told new judges, you need to do justice, but you also have to move the product. Under normal circumstances, the courts where I sit regularly have little backlog. Of course, the last year has been very challenging for the judicial branch and matters are not being resolved as quickly as usual. I am proud that in Lincoln and Saginaw counties, where I sit primarily, we are still resolving cases. And as a result, we have a smaller backlog than many other parts of the state. I am sure it is not just my work on the bench that impacts the backlog, but also the environment that is created between myself, the hardworking court staff, the attorneys, and the litigants. We certainly don't always agree or see eye to eye, but by fostering an environment of mutual respect, I have helped shape the efficient, effective, and just resolution of the important matters pending before me. Thank you for your time and your consideration of my nomination, and I would be glad to answer any questions.
Thank you very much, Justice Billings. And I see that we already have a question. Representative Harnett, you may proceed.
Thank you, Madam Chair, and thank you, Justice Billings. And I was happy to hear that you were born in Gardner. I represent House District 83, which includes Gardner, where I live. I want to ask you about the reappointment questionnaire you filled out. I was very struck by your answer to question 3F about the most important lesson that you have learned being a sitting justice. And that was to do as much as you could to avoid incarceration. And I found the reasoning for that very sound, very thoughtful. I'm just wondering if you could share more with the committee what led you to that change in position where it may have been more of a default in the beginning, and now you take as many steps as possible to avoid incarceration.
Yes, I'd be glad to expand on that answer. First, I should say and preface my remarks by saying one of the important things that the court does in criminal matters is holding defendants accountable for their actions, whatever actions that they are convicted of or plead to, and that's an important part of the process and shouldn't be forgotten when the court imposes a sentence. Second, there are some folks, unfortunately, who need to be incarcerated due to public safety concerns, and the court shouldn't forget that. So I need to preface my remarks with that. But over the years, I've come to believe that the number of people that actually have to be incarcerated is fairly limited. There are certainly people that work their way there, despite the number of chances that we give them, and we have to impose a period of incarceration simply for accountability and for the system and the sentences the court imposed to have any meaning. But I don't believe that incarceration in and of itself solves the problems that brings most of the people before me on my criminal docket. Most people that end up in the criminal courts in our state, and I have no reason to believe it's not the same around the country, are there for many reasons. Poverty, mental illness, substance abuse issues, or all too often a combination of those. And locking someone up for a period of time doesn't make those issues go away, and in many cases could actually make them worse. I've learned that over the years. I think I always knew it to a certain extent, but I was more likely to accept a convincing argument from a prosecutor that at least a short period of incarceration up front was necessary. Now I'm less sure of that. And again, everything is in a case-by-case basis, and certainly some cases that is appropriate. I think our experience in the court system over the last year has supported that conclusion. We have worked very hard in the judicial branch and with prosecutors and defense counsel and probation and parole and the jails to keep our jail numbers down over the last year because of the global pandemic. Every time you send somebody into a jail, it puts them at risk, puts the other inmates at risk, and it puts the staff at risk. So we've worked hard to try to limit the number of folks who are held pre-trial. And I think we've done a particularly good job of that in Region 6, but I think it's been done well around the state. The jail numbers have stayed manageable because of the efforts of all the people I mentioned. But from my experience, people who would have usually been held a year ago, even by me, pre-trial, have generally taken advantage of the opportunity they've had to be on the outside pending trial to address their issues. I can think of a case I dealt with very recently in Rockland, where based upon the underlying charge that the person was on probation for and the nature of the probation violations that were alleged, that person would have likely been in custody all the way up to the point where the case was resolved. That person was given an opportunity at bail, not by me, but by one of my colleagues, And I think the fact that we're in a pandemic played a major role in that. And that defendant took advantage of that, got into treatment, and had a much stronger argument to make at sentencing. And I think it's safe to say significantly reduced the amount of time that ultimately he had to serve because he was able to prove himself while being out on bail. So it's just, ultimately from experience, and that obviously there are people who particularly on probation or who are on bail who are given a chance and despite that continue to violate, ultimately they end up being incarcerated because if you don't take some actions, the court's orders tend to be meaningless. But over the years, I've learned that the number of occasions we need to do that are less than what I may have thought, 8 or 9 years ago.
Thank you. Thank you very much.
Yeah, thank you. Representative Babbage, would you like to proceed with a question?
Yes, I would. Thank you, Madam Chair. Justice Billings, I appreciate your testimony and your introductory remarks and your answer to that last question. I find you very impressive. So a couple of people, Ms. Thompson included, and yourself, talked about the efficiency of moving the docket. And I just wanted to ask you as a non-attorney, how that manifests itself. We want to make sure that justice prevails, but what is the secrecy, the secrets to moving the docket, making some people happy, but not infringing on justice being done. Thanks.
There's probably no secret to it, but there's a number of different parts to that, and I think probably the first part of it with parties who are represented is to get the parties to talk and to focus on the real issues that are in contention. Sometimes lawyers fight amongst themselves and fight about procedural issues or discovery issues and really get distracted from the real issue in the case. And when I'm able to conference with attorneys in civil or criminal cases, I talk plainly to them, and I think I'm able to convince them to focus on the real issue of the case and what's really in dispute, not whatever might be this sideline dispute that may be slowing things up. The second thing I do in the criminal process with the Unified Criminal Docket, part of the process is dispositional conferences. Those are cases where that's a part of the process where a defendant is pled not guilty and there's been discovery and some time for the parties to consider the case, where usually lawyers, but sometimes the prosecutor and a pro se defendant get together with a judge in a less formal process to talk about the case and about ways the case can be resolved. And in those cases, I'm fair to say actively involved, and I'm not afraid to offer opinions, both about what might be reasonable to resolve the case and why one party or the other's view of the case may be misguided. Obviously, I'm a judge, I'm not an advocate, and the lines, how you make those remarks and the lines that you have to live with have to be taken into account. And obviously, if given too strong an opinion on a case, it might be appropriate if the matter moves forward to trial that someone else handle it. But I've heard both from prosecutors and defense counsel that having a judge who's not afraid to offer an opinion on some of those things helps them move the case forward, helps them make a decision about either changing an offer or accepting an offer because the court's been willing to offer an opinion. And then the third thing is obviously managing in the courtroom. If you have a contested hearing, allowing people to be heard, there are important due process rights to be respected, but not to let things go off the rails. And that's a fine line. some days I probably err more on one side, and some days I may err on the other. And again, I think that's just something that you learn from experience. I think it also helps when you have experience with the lawyers who appear before you regularly, and they know that you're generally fair and let them do what they need to do. And when you gently, if you have that relationship and that respect with counsel, and you gently edge them along, it's better accepted because they know that you're fair as allowing, in regards to allowing them to make their case. And then I guess the final thing in this area is just being aware of the numbers, being aware of your docket, staying up on top of the list, knowing what's pending before you. I have a good memory, and I tend to remember those things, and I'm a numbers person, so just sort of by the way my brain works naturally, that comes easy to me. So it's a combination of things. And again, there's always a line there, because certain cases take time to get resolved, and you wouldn't be doing justice if you push them ahead too soon. But on the other hand, there are other cases that if you don't push, they'll never get resolved.
I appreciate that. I appreciate the multifaceted answer that you've offered there. If I just had a follow-up, Madam Chair, I guess it would be, do requests for continuances come up a lot? And is there a criteria that you use on whether to grant them? Or I just wondered if that was something that you had to deal with a lot.
Yes, I mean, all judges, the basket work. So basket work, and our job is just that. We all have an in basket, and the clerks who process and docket materials put it before the appropriate judge. And when we come in, we look at those matters and decide on them. Sometimes they may be more substantial matters that we have to set aside and consider, but often it's things like motions to continue and so forth that you deal with in a quicker manner. Again, it's a case-by-case situation. I tend to be very easy with granting motions to continue up front. I'd rather give parties and lawyers time to be properly prepared before they come into a dispositional conference or pretrial conference in a civil matter. Just pushing them to come in for them to tell me that they're not prepared really doesn't serve anyone. So early on, I tend to be pretty easy about granting continuances. And part of that is, a lot of the attorneys who appear before me know that at some point, I'm going to hold their feet to the fire and that they can't push that forever. Later in the process, if we're on the verge of trial or jury selection, back when we used to select juries, the standard's harder for me. There needs to be a substantial reason why an older case needs to be continued. So it depends obviously on the reasons, but also to me partially on where we are in the process. And I think this is also an area where the fact that I'm have a good memory and am directly involved in these conferences helps. I can remember when I first started sitting on Superior Court and I was doing a docket call in Knox County. The first docket call that I did down there, an attorney had an older case, but a good explanation about why he needed a continuance, was sort of suggesting that if we put it off to the next trial list, he'd probably get his client to see the realities of her situation, and maybe we'd be able to avoid a trial. Knowing that attorney to be a hardworking person of good faith, I granted the continuance. A couple of months later, we're back at the next docket call, and the attorney is making the same arguments. And at that point, I said, counsel, I understand where you are. I've been in your position in the past, but you were telling me the same thing 2 months ago. It was a good argument 2 months ago. It's not a good argument today. You need to talk to your client, and either she accepts the plea bargain or we go to trial. And again, that's, having that direct discussion with the attorney the first time put me in a better position to hold his feet to the fire the next time around. And the attorney, who's again a very good attorney, you know, sort of dropped his head and nodded, and we got the case done, frankly. Again, there's no magic to any of it, but again, as Chief Judge Laverdier said, realizing that it's part of the process. If you let one case take over your docket, there's going to be all sorts of other cases, and it's not just cases, all sorts of other people, real people who have their matters delayed because you've allowed one matter to sort of overtake you. And it's just something that we need to keep in mind.
Thank you, Justice Billings, and thank you, Madam Chair.
Thank you.
Representative Evangelos, do you have a question?
Thank you, Madam Chair. Good morning, Justice Billings. My first question was covered by Representative Harnett. I'm very impressed with your answers on the questionnaire, working to avoid incarceration, take the pressure off of our jails and prisons. My second question, and then I have a third item, but my second question, after you assumed your judgeship, I noticed almost immediately you made several impressive rulings supporting people's First Amendment rights to peaceably assemble, some of them around peace activists, which I really appreciated. My question is, you seem to have a really healthy respect for the First Amendment, and I'd like you to elaborate on that for a minute.
Sure. I appreciate that, and I appreciate those remarks. I will say that when I was in law school, independent writing project that I did focused on some free speech issues. When I was in practice, I was involved with campaign finance issues and election issues, and obviously those issues are all involved, First Amendment and so forth. So it is an area that I have a particular interest on. Frankly, it's not something on my day-to-day work comes up all that much. I'm good friends with Federal Judge Walker, and I occasionally tell him that we leave the Constitution to the feds. Again, I don't really mean that, but a lot of those cases usually end up in federal court and not in the main superior court, but they do from time to time. And one case, two cases that went to jury trials involving folks who were protesting outside of Bath Iron Works. The first case went to verdict. It was, I believe the charge was obstructing a public way. And the defendants were ultimately convicted in that case. But one of the things that I did in the trial that probably gave the prosecutor some concern early on, but I think as the trial went along, they understood the wisdom of my decision, was I allowed the defendants to explain to the jury why they did what they did. And the reason for that, the legal reason for that, is the statute makes it a crime to unreasonably obstruct a public way. It's not simply every time you obstruct a public way, you're committing a crime. It has to be unreasonable. Now, I would admit it was probably the legislature's intent in including that language to think about things like vehicles breaking down, those kind of things. But I read it more broadly and allowed the defendants with reasonable time limits to explain to the jury the important reasons that they were protesting and why they thought it was important to do what they did. And frankly, I think it made the trial go better because I wasn't trying to keep my thumb on the defendants, most of whom were self-represented during the trial. They knew ultimately they'd be able to have a chance to tell the jury what they wanted to say, and they did that. Jury considered that along with the evidence presented by the state and made their decision. In the second case, which was at least legally more complicated, the defendants were charged with trespassing. There was a christening of a ship at the BIW. They approached the gate that the public was being allowed to enter to watch the proceedings, and they were immediately turned away. And then when they refused to leave, they were arrested and charged with criminal trespass. The issue that came up there was that when a property is being made even private property that is being made open to the public, denials of individual members of the public entering that property have to be reasonable, particularly if law enforcement is then going to act upon that denial and charge somebody with a crime. And it came up in the evidence that the security supervisor at BIW noted that if members of BIW's workforce who were coming to the christening happened to stop and talk to the protesters on their way to the gate, they would be turned away from the christening, even if they were employees of BIW. And so ultimately, at the end of the state's evidence, a lawyer who represented some of the defendants made a motion for judgment of acquittal, which I ultimately granted because I believe the actions of law enforcement were unreasonable under those circumstances, because you can't exclude someone from a public place or a private place that's being open to the public because of their lawful use of their First Amendment rights. And I think those examples are important because when people come before the court has to focus on the law and the facts and not the perspective of the defendant. And again, these cases, there's obviously, political protests were involved, but it had nothing to do with my decision, whether I agreed with what they were saying or not. That's just not what courts should do. And frankly, I think not what my colleagues on the main trial courts do. I think folks are able to put those things aside. But it's really critical for trust in the courts that people believe that they can get a fair shake, even if the judge may not agree with them on their political views, but it's ultimately not what the court is making a decision on. And they were certainly, frankly, they were interesting cases. It's fair to say the defendants in those cases were not typical criminal defendants. And one of them went on to run for the US Senate, and not typical issues I deal with. And it was also interesting, despite what you may see on TV, most of the cases that come before me, there's not a lot of spectators sitting in the gallery. Occasionally, maybe some family members, people involved, but it's usually a pretty small room if you have even a criminal trial, even a significant, serious criminal trial. And this was one of the few days where you go to work and when they come out on the bench, the room was full. Again, back when that was safe and appropriate. So they were interesting cases, and appreciate your question.
Thank you. I liken and attest to the fact that you don't let your political beliefs interfere in anything you do, because in 2004, you were the Republican attorney for a recount involving my election, which I lost. But there were 27 disputed ballots. You were representing my opponent and his party, the Republican Party. There was no Democrat, just me. And you ruled for 26 out of the 27 in my favor. And it spoke to me then. I went over and shook your hand when I lost and thanked you for your fairness. So you're a man of integrity. So thank you for that.
Thank you. I appreciate that. And I can't say I remembered that level of detail. I did a lot of recounts over the years, and I did remember representing former Representative Richardson in that case, and frankly wondered whether you remembered it and whether it was a pleasant experience or not. I didn't remember our interactions as you did, but I did approach my work in those cases. As a lawyer, I approached my work in those cases as the election was over, the ballots had been cast, there's standards by which ballots are to be counted and not counted. And I represented my clients of applying the law to the facts. And I tried not to make it a continuation of the election, because frankly, I don't think that's good for anybody. And frankly, sometimes I think recounts get a bad name because that's what people think they're about. And maybe in some cases it is what they're about, but that was never my approach. It's, digging into the boxes and seeing what's there, and somebody won and somebody didn't, and we all move on.
Well, you did well, and trust me, when you lose one, you do remember. So thank you for that.
Years ago, but I've been there myself, so.
Committee members, does anyone else have a question for the nominee? I'm looking around. I don't see any additional questions for the nominee. Thank you very much, Justice Billings, for your statement and for your thorough and really interesting answers to the questions today. We'll now turn to statements from the floor. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but does not wish to speak should have submitted that statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chairs, at which time they will be promoted to a panelist status in our electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comment concerning the suitability of this particular nominee for this particular position is considered in order. All other comments will be ruled out of order. After you are done speaking and there are no more questions from the members of the committee, you will be returned to attendee status and the next person will be called. At this point, I see that that our first member of the public has joined us as a panelist, and that is Logan Perkins. And Ms. Perkins, you may proceed when you're ready.
Thank you, Madam Chair. My name is Logan Perkins. I live in Swanville, and I am an attorney. My practice is in Belfast in Waldo County. I practice almost exclusively indigent criminal defense. I serve both as a court-appointed counsel for state cases, as well as on the Federal Criminal Justice Act panel in federal criminal defense, in my federal criminal defense practice. I wanted to tell the committee a little bit about myself. I've submitted written testimony in support of this nomination, but I wanted to contextualize that first by saying that I would not be here before you today, save for a number of things, but one step on my path to the law, which as Justice Billings, I didn't know I had this in common with him, but I also was 8 years between undergrad and law school myself, and I did a lot of things in that time period as well. One of the things I did was act as an intervener along with a number of my friends in before what used to be LURC on the Plum Creek rezoning process, the application to rezone a large section of the North Woods. And Assistant Attorney General Jerry Reed was deeply involved in that process as well in his capacity in the Attorney General's office. And shortly after I had an opportunity to question Plum Creek's air quality expert about the testimony they were presenting to the Land Use Regulatory Commission at that time, Assistant Attorney General Reed pulled me aside and said, geez, you really ought to go to law school. And then I did. So you all have him to thank for that. I had the distinct pleasure of appearing before Justice Billings for a jury trial in the Bath Ironworks case that Representative Evangelos and Justice Billings were just discussing. I did represent a number of the defendants in the second case. This was the criminal trespass case. And I did advocate that First Amendment defense, some of which I've outlined for folks in my written materials. I will say, though, that I also have the pleasure of seeing Justice Billings in more regular criminal defense work. While I mostly practice in Waldo County, I'm occasionally appearing in Knox and other places where he frequents. But I will say it's an unmistakable feeling to walk into the courtroom, or these days appear on Zoom, and see that Justice Billings is on the bench, the feeling is one of excitement and joy and optimism as a defense attorney. And that really, to me, is such an important part of my job. I think this committee is aware and has heard a lot about the sort of morale problems in the court-appointed criminal defense bar right now, associated with widespread criticism or maybe some unbalanced reporting about what it means to be a practicing indigent criminal defense attorney in Maine. But when you see Justice Billings is on the bench, you know that your day is about to be characterized by humor, friendliness, compassion, as well as a quick, agile, and forceful intellectual repartee with Justice Billings as we move through cases for the day. I have to say, for me, that is one of the highlights of my job. What I really love is to be able to walk into a courtroom and know that whomever is on the bench will take seriously my arguments, will pay attention to what I have to say, and will view the case before them with an open mind and a sense of humor and a willingness to really engage around both the principles of law and fairness that dominate our criminal justice system. So it is a distinct pleasure to appear before him, and it is a distinct pleasure to appear before you all today to recommend his reappointment to another term on the Superior Court bench. I will say that I'm happy to take any questions the committee has, but really Justice Billings is, as has been said, one of the good ones. And from in the trenches, I can say that he is a real asset to the bench, and I appreciate the concerns this committee has been wrestling with respect to indigent defense. And I think Justice Billings is well positioned to help us as we continue to navigate those thorny issues, and is, I think, well regarded in general by the defense bar. I would also just say that I have many colleagues and compatriots in the criminal defense bar who share my views of Justice Billings, and who turn to him and rely on him and his wisdom and his intellectual prowess when we have a thorny issue or difficulty negotiating a case with the state, or when a case really needs a hearing. It is always a pleasure to know that he is the justice assigned to the case. So with that, I'm happy to take any questions.
Thank you very much, Ms. Perkins. Committee members, does anyone have a question for Ms. Perkins? Seeing none, we appreciate you being with us this morning and providing your statement. And the next person here to speak on behalf of the nominee is Sheldon Tepler, and he is making his way onto the panel and will be with us in just a minute. And Mr. Tepler, when you have joined the panel, you can activate your video and audio and proceed whenever you're ready.
Well, my video should be on, but I don't see myself. Can you hear me?
We can hear you, but we can't see you. Let me see if there's a button here that says ask to start video. I don't know if this will make it any easier for you. Does that help at all?
It's helping.
Oh, there we go. Welcome to the Joint Standing Committee on the Judiciary, and you may proceed when you're ready.
Thank you. My name is Sheldon Tepler. I live in Topsom, and I am a partner at Hardy, Wolf & Downing, which is a plaintiff's firm. We represent people who have been injured. I was going to launch right in and not take a lot of time. However, I have been listening for the last 45 minutes, and I have to say one thing. I'm the child of Holocaust survivors, and I'm the father of 2 asylum-seeking boys. And I'm just so moved by this wonderful process. I mean, for those of you who aren't children of Holocaust survivors or familiar with that, I don't know if you could imagine what it means to be part of this amazing democratic system. That being said, let me speak about Justice Billings. I know him when he practiced with Dubord. I knew him as a man with a keen mind. I knew him as a man who was a legal scholar. I've gotten to know him better as a judge. I probably had one of the last trials in front of him, which was just a few months before COVID. I have heard a lot about his scholarliness, his ability to move the docket. What a pleasure it is to be in front of him. And I want to talk about his fundamental decency for a moment. I do not judge a person by how they treat their peers or people who are in a greater position of power. I judge a person by how they treat those who may be younger, in less of a position of power, people who are just beginning. He's always treated me great, but so what? You know, I'm an old dude. I've been, you know, a lot of people treat me well just because I've been around so long. What I was impressed by was how he treated my associates who went before him in several trials. There is none of this locker room kind of talk in chambers that makes new attorneys feel uncomfortable. There's not this basketball, football talk that makes people who aren't part of the clique feel uncomfortable. It's just decency and friendliness to the new attorneys who work in my office. And that is something I appreciate. My associates have uniformly come back and said, what a nice man. He treated me with such respect. I really thought I got a fair shake. And they said, does he have a particular political bent? I think that speaks volumes about him. In my last trial, which I did with my associate, I just felt like it was a pleasure to work. It's not like he was giving me any special treatment. It was, you know, I made my motions, he ruled, sometimes for me, sometimes against me, was always friendly, polite, deferential, not only to me, but to my young associate. And when we went to trial, you know, it was just a real orderly, efficiently done case. Someone spoke about what's the secret to moving cases along. Well, you know, it's pretty simple. Sometimes you got to say to people like Sheldon Tepler, I heard your argument. Thank you. Point taken. Now let's move on. You're not going to convince me otherwise, Mr. Tepler. It's perfectly fair. You know, people have to tell me to, it's enough. Otherwise, I'll keep on going. And Justice Billings did that in the most polite, just in the most polite way. Needless to say, the courtroom moved efficiently. The court staff moved efficiently. He's great. He is great. All around judge. Happy to take questions. And once again, thank you for letting me speak. Please, someone have a question.
We do have a question for you. Thank you very much for your testimony here today. And I see that Representative Babbage has a question for you.
Well, actually, thank you, Madam Chair. Actually, Mr. Tefler, I wanted to thank you for your comments about the nominee. but I also wanted to say, as a career history teacher, or now student of history, I really was touched by your reminder to us of this special process.
Oh, it's so moving. And, you know, every time I go into the courtroom, I shouldn't say every time, sometimes it's annoying. But I just remember going, my last trial, which was in October or November, and happened to have been in front of Justice Billings, pinch me. It's just amazing that that there's the rule of justice and decency. I mean, I just am so proud to be an American. Sorry for getting emotional about that, but hey, you allowed me to speak, so I am. And
Well,
Justice Billings, thank you for being the man you are. I really appreciate it. I hope that wasn't inappropriate for me to do.
No, we appreciate your reminder of why we're all here and also your comments today. Committee members, are there any other questions for Mr. Tepler? Not seeing any. Again, thank you very much.
Thank you. Have a good day.
You too. And next we'll have Kelly McDonald, and he has joined our panel. Mr. McDonald, you may proceed.
Thank you, Senator Carney and members of the judiciary. Do I really need to follow that? Can we rearrange the order here a little bit? Those were some beautiful words. My name is Kelly McDonald. I'm a resident of Portland. I'm a lawyer at Murray, Plum & Murray, and I am currently serving as the president of the Maine State Bar Association. I'm delighted to be here today on behalf of the association to support the nomination of Justice Billings to his seat. As we discussed earlier today, the association sends out questionnaires to all of our members across the state looking for feedback on sitting judges in the 6th year of their term. We gather that information and report it into this committee in support of our position. Our members describe Justice Billings as being an excellent jurist with a sharp legal mind. He's considered to be articulate, professional, well-prepared, and thorough. Maine lawyers also find him to be conscientious, patient with all litigants, and good-humored. He is committed for his strong sense of fairness and justice, and for his treatment of all individuals in his courtroom with respect and dignity. These traits have earned Justice Billings the support and respect of the Maine State Bar Association members. We believe that Maine citizens will benefit from his continued service on the Maine Superior Court. From a personal perspective, I'm also delighted to be here to support Justice Billings' appointment. I do civil litigation, but my particular practice has me appearing in courts relatively rarely, especially specific courts. And so I appear in front of Justice Billings less than a handful of times within the past couple of years. And I'm always honored and delighted when he recognizes me and says, "All right, Attorney McDonald, what's going on in this case?" And he's talked about his excellent memory. I have a terrible memory for faces. And so I doubly respect his ability, even after it may have been years since he saw me, to recognize me. I have also been witness to what he described to you as sitting in his chambers to talk about a case with opposing counsel and being subjected to his analysis of the potential challenges that each side faces. And I think that as he described, I can report that that does in fact help move the parties towards a common understanding of the issues. On behalf of myself individually, but also on behalf of the association, we are delighted to support the renomination of Justice Billings to his seat. I'd be happy to answer any questions the committee might have.
Thank you very much, Mr. McDonald. Committee members, are there any questions for Mr. McDonald? I'm not seeing any. Thank you for being with us this afternoon now. Thank you for being with us today, Mr. McDonald.
Unfortunately, I will not be with you this afternoon, but others from my association will be. Thank you all for your time this morning.
Thank you. And now we are joined by Lori Boxer-Maycomer, who is here to present testimony in support of the nominee. You may proceed.
Great. Good afternoon, Senator Carney, Representative Harnett, and the Judiciary Committee. My name is Lori Boxer-Maycomer, and I'm here today to testify on behalf of the Maine Trial Lawyers Association in support of the reappointment of Justice Billings. I understand that you may have heard from some of my colleagues this morning about our process, but it's very similar to the one that you heard Kelly McDonald talking about for the Maine State Bar Association. We survey our members about candidates and reappointments. And in this particular case, we received back primarily a majority of feedback in favor of Justice Billings' reappointment. One respondent that spoke highly of Justice Billings said that he was a very good jurist who respects those in his courtroom. Another piece of positive feedback that we received was that Justice Billings was intelligent and prepared. We did, I know you all like to hear about the good and the bad. We did have one remark that was specifically said that Justice Billings was involved in political matters and did not demonstrate ethical competence in recognizing his position as a member of the judiciary. But given that this last comment contrasted with the generally positive reviews provided by a majority of our respondents, our association felt comfortable supporting the reappointment. And in addition, we went back and looked at prior survey responses on Justice Billings, and those were generally positive. And we looked at his previous practice and government service and experience before joining the judicial branch and felt good about that as well. So based on the high remarks from the majority of our memberships in response to the survey, we would like to endorse the renomination to the Maine Superior Court, and are very grateful and want to thank Justice Billings for his willingness to serve on the bench again. And I'll take any questions.
Thank you very much. Committee members, are there any questions? Not seeing any. We appreciate you being here today and providing the information. And let's see. I do not know if there are others who have signed up in advance to testify. Let me just turn to those who are listed as participants. So I see that we have an additional person joining us. Mr. Mason, welcome to the Joint Standing Committee on the Judiciary, and you may proceed when you're ready.
Thank you, Senator Carney. Thank you, members of the Standing Committee. My name is Jim Mason. I am a resident of Brunswick, where I also practice with the law firm of Handelman and Mason. I'm a partner there. We focus pretty much exclusively on criminal matters, and as that, I work throughout Southern Maine and the Mid-Coast, and so I am in court very often. I probably don't believe there's any judge I appear before more than Justice Billings. And so I'm very happy to be here to support his nomination. It's likely that I've appeared before Justice Billings in probably over 1,000 criminal cases. I've tried jury trials with him, and including of note, one bench trial. The most fundamental right that comes with with all cases in our justice system, but certainly criminal cases, is the right to jury trial. And probably the highest compliment of fairness that I can give to a judge is that a fact that I have more conversations with attorneys about holding bench trials when we know that Justice Billings is going to be the judge. We all know with confidence that he firmly believes in the idea of proof beyond a reasonable doubt. And I have no confidence that even when I think that he may think that it's possible that my client is guilty of the charge, I can still with confidence go to them and say, he will hold the state to its burden to prove their case beyond a reasonable doubt. And I think we may not do it very often with bench trials, but the fact that over and over again, I have that conversation about Justice Billings, I think tells you quite a bit about how he's viewed and his fairness. I can agree with Justice Billings and Mr. McDonald and several others who have spoken that Justice Billings does not shy away from giving you a good analysis of your case. I've had plenty of conversations with him and dispositional conferences about the case, the strengths and weaknesses. I've used those conversations. I've used those conferences with conversations with prosecutors and my clients to end up resolving cases that might have otherwise gone to trial. I've also unsuccessfully appealed a number of his decisions to the Maine law court, so I can attest to the soundness of his legal thinking. But more than that, I mean, I think you've kind of gotten the flavor of this from the people, that he knows that this is a system comprised of people. And I can agree that he has fostered a really good relationship with the bar, both the civil that I've had some exposure to and the criminal defense bar, that these are people who know they're going to have working relationships for years. And he's the head of that for our little bar of Saginaw and Lincoln, where I practice most of my cases. But importantly is that not just members of the bar, as I think Mr. Tepler talked about, it's easy to talk about and be nice to members of the bar when you're a lawyer. He's very good with criminal defendants too. I think he treats them with respect. He knows they're not just the allegations that they've been charged with. I've seen him admonish criminal defendants for really poor behavior, and very appropriately so. But I think importantly, very importantly, I've seen him, I think, genuinely praise people for when they've come back before him after a period of time and they've maintained sobriety. I've seen him sort of compliment them and try to encourage them when they've really turned their life around. I think that's an important part of justice too. I really do count myself lucky to appear very regularly in front of Justice Billings, and I offer my full support. I know this has been going on very long, so I'll shorten my comments, but if anybody does have any questions, I'd be happy to answer them.
Thank you very much, Mr. Mason. Committee members, are there any questions for Mr. Mason? I am not seeing any. Thank you for being here this afternoon.
Thank you all very much.
I believe we have one additional person who wants to speak with regard to this nomination. And we will bring her over from the attendee space in just a moment. And Ms. Dakers, thank you very much for being here today. Could you please state your name and your town of residence, and then you can proceed with your remarks.
Yes, thank you very much. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I very much appreciate your time this morning. I know this is going late, but I really want to speak on behalf of Justice Billings. Again, my name is Katie Dakers. I live in Scarborough, Maine, and I currently work as an assistant district attorney in the domestic violence unit of the Cumberland County District Attorney's Office in Prosecutorial District 2. I have previously worked in Prosecutorial District 6, which encompasses Lincoln, Waldo, Knox, and Saginaw County. My testimony today does not represent the views and opinions of my current or former district attorneys or of the Prosecutors Association. I'm appearing today in my personal capacity and from the viewpoint of a lawyer practicing in the state of Maine. I had the privilege and honor to appear before Justice Billings when I was a new lawyer just starting my career as a prosecutor in Lincoln County. One thing I appreciated, especially as a new lawyer, was the thoroughness and detail with which Justice Billings would explain his decisions from bail hearings to motions to suppress, or when applying the Hewing analysis and rulings at trial. I learned so much from him in every interaction, and I really felt myself to be so lucky to appear before a justice who often felt more like a law professor. Having had the privilege to appear before Justice Billings for a little over 4 years on a weekly basis and argue many motions before him, I was always struck with how fair his decisions were. I think it's no secret that lawyers sometimes feel a particular judge may lean more towards the defense or the prosecution. This is not true with Justice Billings. Now, this is not to say I always liked or agreed with his rulings, especially when he was ruling against me. But with time and the review of the case law, I would see that he was correct and the course of action ordered was fair and appropriate. Something I also appreciated and valued is the way Justice Billings managed the courtroom. From the bench, he acted with absolute respect for all parties and reverence for the judicial institution as a whole. He taught me a lot about how judges and lawyers should conduct themselves in the courtroom by the way he treated everyone. Whether that was a lawyer, a marshal, a victim on the witness stand, or a defendant, they were all treated with dignity, kindness, and empathy. This was all done while upholding and impressing upon the participants the importance and seriousness of the proceedings. Representative Babbage asked how Justice Billings moves the docket. I can speak directly to that in stating that he's really second to none when it comes to managing a dispositional conference. In my experience, his analysis of the cases were direct, honest, and his opinions were grounded in case law, but also narrowly tailored to the case facts, allowing the parties to come to a resolution. It is with the utmost enthusiasm and sincerity that I recommend his confirmation to this committee. Thank you very much for your time and allowing me to speak today, and I'd be happy to take any questions.
Thank you very much for appearing before the committee today, Ms. Dakers. Committee members, are there any questions? I see Representative Babbage has a question.
Thank you, Madam Chair. Just a quick one. We've had a lot of references to dispositional conferences today, and having not taken Law 101, although I've kind of taught sort of along the fringes, is that a mandatory process? What is the frequency of, or is it just a tool? I mean, I wanted to know if a dispositional conference is, ordinary or used differently by perhaps different justices.
It is mandatory. Every criminal case has a dispositional conference, and they, from my point of view, my practice, are very important. Sometimes I might be listening to a 911 call and put certain weight on statements, and that's really what I'm perceiving, especially in the domestic violence case world where many victims, through circumstances or fear of safety, are not cooperative with the state. Recorded 911 calls, statements and medical records are really what move cases forward. And it's those statements that I rely on, and I might be putting too much weight on one that a judge who has more trial experience than me knows may not be so significant. Or they may hear the 911 call and go, oh, wow, that really speaks to the soul of what was happening. Defense, you might want to reconsider this, or prosecution might want to reconsider this. And that is where Justice Billings excels. I've had the privilege to work in a number of counties, appear before 10, maybe more judges, and there's just no one who can do a conference quite like Justice Billings. He really remembers everybody's humanity and the people that you're dealing with. They're not a number, they're not a case. This is a real world person. But he also understands the needs of the public, and to keep people safe. Sometimes they need to do jail time. Sometimes you have to force them into counseling or they're never going to get the help you need. And we'll see them next month when they've hurt the next person. Anytime he wants to come down with Portland, I know I miss appearing in front of him very much, and I would welcome him down here. There's just no one like Justice Billings.
Thank you, Attorney Dakers. Appreciate it.
Committee members, are there any additional questions? And I'm not seeing any. Once again, thank you very much for appearing before the committee today. I don't see anyone in our attendee space who is here to testify at this reappointment hearing, so we will proceed with the conclusion of the hearing. All public comments having been taken, the committee will now proceed as follows. We'll review any additional comments on the nomination that have been received by the committee. And I'll just check in with our committee clerk, Ms. Panette, to see if any additional comments have arrived while we've been underway with the hearing.
There have been none, Madam Chair.
Thank you very much. We'll now move on to vote on the nomination and notify the President of the Senate pursuant to Title III, MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on the Judiciary for the Honorable Daniel I. Billings of Southport for reappointment to the Maine Superior Court is closed. We'll move on to taking of the vote. In accordance with the law, the committee may not take a vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I will inquire as to whether any member present objects to proceeding to the vote immediately. And committee members, please raise your real or virtual hand if you are objecting to proceeding to the vote immediately. And Representative Babbage, I think your hand is maybe up from a previous question. Are you in agreement with proceeding?
I am in agreement with proceeding. Thank you, Madam Chair.
Thank you. And I don't see any objection from any committee member. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Daniel I. Billings of Southport for reappointment as a Superior Court Justice be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of confirming the nomination, recommending the nomination. A vote of no will be against the nomination to recommend confirmation. Is the committee ready for the question? The committee clerk shall call the vote, excuse me.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. 12 members voting in the affirmative, 0 in the negative. 2 members are absent, Madam Chair.
Thank you very much, Ms. Panett. 12 members of the committee having voted in the affirmative and 0 in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of Daniel I. Billings of Southport for reappointment as a Superior Court Justice be confirmed. Justice Billings, we ordinarily would be coming out from behind the horseshoe to give you a handshake and congratulate you. Our tradition for these times is a virtual round of applause, which we'd like to give you now.
Thank you. Thank you.
Thank you for your service to the state of Maine and congratulations.
Thank you. Appreciate everybody's questions and ultimate support for the nomination.
Thank you. Committee members, we have now concluded the second of our hearings for this morning. Our next hearing is at 1:30, and that's for the Honorable Barbara Ramundi, and then at 3, the Honorable Andrew Benson. So we'll take a break until 1:30, And I would ask committee members, if you're not going to log out, to please mute and turn off your video during the break, because the live stream will continue even though we're not conducting any committee business. And we will see you all back at 1:30. Thank you very much.
Good afternoon, Judge Ramondi. How are you?
Good afternoon, Representative Harnett. How are you doing?
I am doing all right, thank you, in our little world of boxes.
I know. Listen, I sat through the morning, sort of stalking, listening to Justice Mullen and Justice Billings, and I have to say, you folks have a long day.
We do. We originally had 5 scheduled for today. We decided that was a bit too much. So
It was ambitious, given how long that they take. They really do seem to take about an hour and a half.
yeah, we use up all 90 minutes, it seems. My wife says hello. She was counsel for the Maine Labor Relations Board, Lisa Copenhaver.
Oh, yes. Oh, tell her I said hi.
Yeah.
I didn't realize that you were a couple.
Indeed.
Yes. How is she doing?
She's doing well. She's retired and figured she was going to ski a lot this year, and then we didn't get snow. So she's hoping for another storm coming this weekend so she can get a couple more weeks in.
Yeah, my husband is retired too. And between the two of us, he said he was going to pop up today and speak against my renomination because he's not seeing me enough on the weekends.
No, Will, I can work my magic and keep him out if he shows up. So.
All right, I consider that a favor. I'm not quite ready yet.
Okay.
All right. Well, I know that you're ready. You're waiting for everybody else to join.
Yep.
So I'll mute myself out.
Okay.
I'm sitting here doing some paperwork anyway, and
All right.
hopefully I won't miss you when you start.
You won't. Take care.
You too.
Back for rounds 3 and 4, John?
I am. Those were nice hearings this morning, I thought.
I enjoy this process, actually. I think it's, the committee learns a lot.
Well, I do too, every time. Every time.
Good afternoon, John.
Good afternoon. I actually stepped out for a few minutes over the lunch break just to enjoy this incredible spring weather we're having.
What's it like outside? Is it gorgeous?
Oh, it is. It is fabulous. It seems to me that it's maybe even in the low 60s and it's sunny and it's everything it is before the rug gets pulled out from underneath you and you get an April snowstorm. But
we always get one. We always get at least one.
Seems like it.
Last year it was May.
Yeah.
Is it really?
Yeah, the last snow was in May. I remember my husband put the lawn furniture out and it snowed on it.
Yeah, that's a cruel trick. But it gives you a sense of what's coming at least in a month or so.
I'm ready.
Yeah, so am I.
Wait for a few more of my compatriots to join us. Going to give it a couple more minutes. Okay, I think I will get us started. Good afternoon and welcome to a continuation of the Judiciary Committee's meeting of today. We are continuing with our judicial confirmation hearings. I hope everybody got to enjoy the break and heard that it's beautiful outside. Excuse me. So this is the third of our 4th hearings of today. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the Governor of the Honorable Barbara L. Ramunde of Brunswick for reappointment as a district court judge. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendations to the President of the Senate. Today, the committee will hear testimony from and have the opportunity to question the governor or her representatives, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting is being recorded and will be available to view on the committee's YouTube channel soon after this afternoon's meeting concludes. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Moriarty for the purpose of making such a motion.
Thank you, Mr. Chairman. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Barbara L. Ramunde of Brunswick for reappointment as a district court judge.
Thank you, Representative. And I would recognize Representative Erin Sheehan for a second.
Thank you, Mr. Chair. I second the motion.
Thank you. The statutory requirements for this position were made available electronically, as part of the notice of today's hearing and can be found online. At this point, the chair recognizes Jerry Reed for the purpose of making a statement concerning this nomination on behalf of the governor. Mr. Reed, welcome.
Thank you. Good afternoon, Representative Harnett and distinguished members of the committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this afternoon to speak in support of the nomination of the Honorable Barbara Raimondi of Brunswick for reappointment to the Maine District Court. Judge Raimondi has impressive academic credentials. She has an English degree, magna cum laude from Connecticut College, and a master's degree in American literature from Boston University, also magna cum laude. And she received her JD from Boston University, where she was a member of the Law Review. Since graduating from law school, she's dedicated her career to serving Maine citizens through the law. Before her appointment to the Maine District Court in 2014, Judge Raimondi had a distinguished career in private practice, focusing on family, probate, real estate, and criminal law. She was also active on numerous boards and commissions, reflecting her outstanding reputation, including as president of the board of directors at Pine Tree Legal and trustee and president-elect of the Maine Bar Foundation, the charitable arm of the State Bar Association. Since being appointed, Judge Raimondi has presided primarily in Wiscasset and West Bath district courts, while occasionally presiding in Rockland and Belfast as well. Judge Raimondi is known as a highly knowledgeable and effective judge who commands respect in the courtroom with a calm but firm demeanor. On behalf of Governor Mills, it's my pleasure to request your support for the nomination of the Honorable Barbara Raimondi of Brunswick for reappointment to the Maine District Court, and I'd be happy to answer any questions that you may have.
Thank you very much, Mr. Reed, and thank you for being with us again this afternoon. Are there questions from any committee members for Mr. Reed? Seeing none, thank you very much again for your testimony, Mr. Reed, and I will now turn to John Hobson, who chairs the Judicial Selection Committee. Mr. Hobson, welcome.
Thank you very much, Representative Hartnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills' Judicial Selection Committee. On behalf of the Selection Committee, I request that this committee act favorably on the renomination of Judge Raimondi to the Maine District Court. Judge Raimondi, in many ways, reflects why, is a very good example of why the Maine judicial branch has such excellent judges. She came to this position originally 7 years ago from having a distinguished academic career and then a very successful law practice. She had clearly a public service component while she was in private practice, as you heard Mr. Reed talk about her nonprofit involvement. But she gave up her private practice to go into public service on the bench and become a judge of the district court. And the citizens of Maine are far better for it. What has distinguished her career on the bench is a hardworking work ethic and intelligence, and an ability to be both sympathetic in the courtroom, but firm and be able to control the courtroom. Now, fortunately, a significant component of Judge Raimondi's private practice was in civil practice, and a significant component of that had been in family law. And as she's taken on her tasks at the district court, it's been important because of the family law component that exists not only in the district court, but in this COVID-19 times, the backlog that has been created in those cases. And she's been able to basically address those issues and deal with family law matters, both because of her experience on the bench, but importantly because of her basically career in private practice prior to that. She's been able to basically have the docket move, but get the job done with, as I say, intelligence and at times a sense of humor. So with all those aspects, Judge Raimondi in many ways embodies what the Maine judicial system is at its best, is someone who goes into the system with the intent to provide public service to be able to benefit the citizens of the state of Maine and provide the expertise that has been developed over a career to the citizens of the state of Maine. And Ms. Ramundi has done just that. And the state of Maine and its citizens would be well served if this committee would act favorably on her renomination so that she can continue the excellent job that she is currently doing on the bench. And with that, I would be happy to answer any questions.
Thank you very much, Mr. Hobson, and thank you for being here today. The committee thanks you for your service in chairing this selection committee. It's a very important role that you play, and I want you to know that it is appreciated.
Thank you very much.
I will now open it up for questions from committee members, beginning with Representative Moriarty.
Thank you, Mr. Chair. I just wanted to take this opportunity to thank Mr. Hobson for both redesigning the questionnaire form and for providing us in each and every case with updated and current forms. Much appreciated.
Well, thank you very much, Representative, but I want to make sure I'm the first one to take credit when I shouldn't get it. But in this case, it would be glaring because both Mr. Reed and before him, Derek Langhauser, were really just terrific. I mean, that's really their work and their efforts. And as much as I would like to steal credit for their excellent work, I would be called out if I did that, appropriately so. So well, I just want to make sure that's understood, that they're
fine. Perhaps you can pass that along.
I will. But good. Thank you very much. I appreciate it.
Thank you. Yeah.
Taking credit for when it is not reserved is a hallmark of this city. So you would be in good company, Mr. Hobson. Are there questions from other members of the committee? Seeing none, thank you very much again, Mr. Hobson. We'll be seeing you in round 4 a little later today.
Thank you.
The chair now recognizes the Honorable Barbara L. Raimundi for the purpose of making a statement concerning this nomination. Welcome, Judge.
Thank you. Good afternoon, Representative Harnett and honorable members of the Judiciary Committee. I've been listening in today, and I know that you've already had a long morning, and you anticipate, 2 more hearings today. So I appreciate your service on the Judiciary Committee. My name is Barbara Raimondi, and I live in Brunswick with my husband, Bill. My daughter and her family live in Bodenham, along with my delightful new 8-month-old granddaughter, Zeta. I was first appointed by Governor LePage on May 2nd of 2014. I was in a group that was appointed at that time. I was the only woman who was appointed in that group, and I was the only appointee who had any family matter experience. Of the other 4 members in the group, the 3 out of the 4 were prosecutors. I understand that the committee is interested in knowing basically what I've been doing over the last 7 years and what I've learned. So after my training, I was posted to the Wiscasset District Court. I don't know if any of you have ever been to the Wiscasset District Court. It's a lovely court. It's the oldest operating court in the state of Maine, complete with its resident ghost that you can Google and see on YouTube. I was the only sitting judge in Wiscasset District Court. It's a small court. There's only 1 chambers there. And as the sitting judge in Wiscasset District Court, I did everything that the district court judge is expected to do, mainly sitting by myself. So during that time, I would do child protection, protection from abuse, divorce and family matters, real estate cases, general civil litigation, small claims, disclosures, forceful entry and detainer cases, juvenile and criminal arraignments. And as a district court judge, I also sat simultaneously as a Superior Court judge on the Unified Criminal Docket. And so I actually worked with Justice Billings, who everything you heard about him this morning is true. And he was a great role model and a great mentor for me as I came onto the bench. Working with Justice Billings, I did criminal arraignments, motion days, dispositional conferences, and a limited number of jury trials. I stayed in Wiscasset until July of 2022. I'm sorry, July of 20, when I was transferred to West Bath. But during the first part of my term in Wiscasset, I also traveled around to different courts in Region 6. And so I sat in Belfast, I sat in Rockland, and I also sat in West Bath. In about halfway through the term, the court system put in place a one case, one judge system. And after that, most of us in district court didn't travel as much as we had used to, particularly those of us that worked on the family matter docket, because we really needed to be in one place if it was going to be a one judge, one case system. So the latter part of my term in Wiscasset, I pretty much sat in Wiscasset, did not travel around quite as much. As of July of 2020, I was transferred to West Bath District Court, and I am the sitting judge here in West Bath District Court. Wiscasset's a relatively small court. West Bath is a busier court. Again, with COVID, and also with the one judge, one case philosophy, I've pretty much stayed in West Bath. And since COVID, the district court judges have mostly been doing emergency family proceedings. And so the bulk of what I've been doing is child protective cases, protection from abuse cases, and family matters. We've also done a limited number of eviction cases or forcible entry and detainer cases, but during COVID, the small claims docket, the money judgments docket, the real estate docket, all of that has been suspended. And I hate to think of what it's going to be like when it's no longer suspended and what the backlog is going to look like at that point in time. In addition to my work as a sitting judge, I've also worked on a number of judicial committees. I'm on the Judicial Ethics Committee, which provides advisory opinions to judges and magistrates with respect to ethical dilemmas or issues of conflict. A recent request, for example, was a district court judge whose daughter was going to be working at the prosecutor's office and how that should be handled in the area in which that judge worked, whether there was a conflict, whether there was not a conflict. I'm also on, and I'm the present chair of the Court Alternative Dispute Resolution Committee. And Cadres trains and manages all the mediators that appear in the district court in family matters, in small claims, and also in eviction cases. With the advent of COVID, Cadres designed and put in place a Zoom mediation project so that people in eviction cases could have access to mediation, even though mediators were not coming into the courthouse. The Justice Mead has also just approved a new project that we've been working on, which is a Zoom mediation for small claims cases, which is designed to start picking away at that docket because we haven't been doing any small claims cases. So any landlord who hasn't been able to collect any rent for months, just as an example, has not been able to get into court to be heard. So this is designed to start addressing that backlog of cases. And we are also working on an informational video for people to be able to view as they participate in Zoom mediation. That's just started. They've asked me to be the speaking voice in that, but I'm not sure that I'm going to go forward with that starter. And I think there might be others that are better suited for that. I'm also a present member of the Judicial Education Committee, and we've been asked at this point in time to formulate trainings on the issue of bias and racial prejudice in the court. During admin week, which is about a week away, we are going to have a listening panel comprised of people of color, Indigenous people, and immigrants. We're going to present their concerns and their experience in court as attorneys or litigants to the entire judiciary. That's one part of a 3-part program. Some of it's self-study, and we hope in the fall that we're going to have an in-person program on racial bias. I'm a member of the State and Federal Judicial Council, which is constituted to provide a sharing of information and perspectives between the federal judiciary and the state judiciary, it's a wonderful experience to be able to get together with the federal court judges as well as the state court judges and talk about what's going on in the federal level. I sit in the domestic violence court in Bath, which convenes about once a month. And I can't speak about how successful it is in other courts in the state, but I do have to say, and I want to say for West Bath, that I have the greatest respect for the people that work in the domestic violence court in West Bath. Mary O'Leary does the certified batterers group. Steve Edmondson, who's going to be retiring soon, very much to my regret, is a domestic violence advocate for Saginaw County. And we also, another regular that I see is Christopher Dumas, just a probation officer. They all work closely together in the domestic violence court. In my experience with them, I don't think I can give them a higher compliment than to say that they care. And the fact that they care about the people that they work with really makes a difference. It makes a difference to the gentlemen, sometimes ladies, who are appear in that court, that someone is checking out after them, both to support them when they need support, whether they have problems of homelessness, addiction, mental health issues, and they're also quick to hold people responsible, so that if they're not abiding by the rules, they're quick to enforce the rules in the domestic violence project. So it is a program that I think that deserves your support, and I think it has really made a difference for recidivism, at least in Saginaw County. As far as what I've learned, I have to say, having been a practicing attorney for 35 years, it's certainly a different perspective, when from the bench than it is as a practicing attorney. I truly do enjoy my job. I enjoy people. I learn something every day about the law, about the people who come into the court system. The cases that I hear, since I hear such a broad range of cases, everything from family matters to, small claims cases, it's always something new. I mean, I've heard things, I sincerely have sat on a small claims case where the argument was whether or not a mini horse was a miniature horse. I have sat on cases talking about whether a pig is too fat to be sold for meat. Not something that I was trained in when I went to law school, but something that I became educated in as I joined the bench. And some of the other things that just come in front of the district court, it truly is the people's court. I had one lady talk about not wanting to be a juror because, quote unquote, I like to lie a lot. I have a hard time telling the truth and I have a hard time making decisions. But one of my true favorites was the lady who wanted to be excused from being a juror because she didn't have anyone who could take care of her elephant. And I kid you not, I have that letter on my bulletin board in my office. So it just, it's always a challenge. It's often fun. It's always different every day you come into court. It's a wonderful job and I love it. And I have been honored to be doing it for the last 7 years. Also, the people that I work with are a pleasure to work with. You've met Justice Billings. My judicial colleagues are to a man and a woman. They are helpful and supportive. The clerks are dedicated. The marshals are, good humored and helpful. The lawyers, I have enjoyed the lawyers that have come into the courtroom. And we really do have we have a wonderful bar in the state of Maine. And at least in Lincoln County and in Saginaw County, where I've been practicing, I have very much enjoyed the members of the bar that have come in front of me. But more seriously, as far as what I've learned, I've done a lot of family matters, probably, well, certainly since I've been in West Bath, because that's practically all that we've been doing on our docket is family matters. And it is sort of my particular expertise based on my past practice. But I really did write what I thought I'd learned on my reapplication papers, which is that you do need to bring patience, respect, and an open mind with you every time that you come into the courtroom. Where there is room for doubt, you should be willing to give people the doubt. And I will say that I'm a 12 years Catholic school girl, and so I was always willing to give people the benefit of the doubt at least once. And one of the things that I've learned on the bench is at least once is reasonable. That contentious family matters do not improve with time. They get worse, and that if you can get to them early. You can give people. We have so many self-represented people that come into the district court. They don't know the process. They don't understand the system. They don't know what's expected of them. The sooner that they can talk to a magistrate or talk to a judge, get some guidelines and get some understanding as to just what the rules, guidelines, what law is in their family matter cases, the more likely they are to be able to resolve their differences. And if they're not able to resolve their differences, the sooner that they can get in front of a judge or a magistrate, the better, because it doesn't get better with time. As a judge, decide as quickly as you can that by the time people actually get in front of a judge for a contested family matter hearing, it can be a year. In these COVID times, it's a lot longer than a year, which is really tough in these family matter cases. People are exhausted. They really, they want a decision. They want it as quickly as possible. Not to take a slam at the lawyers that I love that appear in front of me, but if they have lawyers, they're also broke. They want to get the process over with. They don't want to spend any more money on attorneys. They really need resolution one way or the other. I think it's also important to explain yourself and make findings. And that's something that I brought with me from my time as a practicing attorney in family matters. And that I've found to be true as a judge. People need to understand why you are deciding what you're deciding. They may not always agree with your decision, but if they understand that you heard them, that you considered all of their arguments, and you address their arguments and your findings, they are much more likely to accept your findings. And I think it's also helpful if you're ruling against somebody, if you give them some guidelines as a path forward. They may not like your decision, but if you say, well, if you do this, then you might get a different result. I think that's helpful as well. It's been helpful, I think, also that I tend to make extensive findings in my cases. I will say, and I don't want to jinx myself by saying it, but I've had it, there have been a number of appeals to the law court, and I have not been overturned by the law court on any of my decisions yet. And finally, I'd like to say that I have found that the poorest of Mainers, and sitting in Wiscasset in particular, Wiscasset is a strange place. There are some fairly wealthy people there in Wiscasset, but there are a lot of people who are quite poor. You know, the clammers and the worm diggers, you know, and sometimes the fishermen. And I have found that in the cases that I've had to deal with them, you know, criminal cases, small claims cases, whatever disputes that they might have, that the poorest of Mainers are often the kindest because they understand hard times, and they are more likely to understand other people who are having hard times than some of us are. And it's been an education to experience that, see that, and learn that in the courtroom. So in conclusion, I guess I'm thankful that I was entrusted to do this job 7 years ago. And I really have tried to do my best to do my job well and to do it fairly. I've enjoyed my work. I find it very rewarding. I think that I have served the state and the people of Maine well, and I hope you will give me the opportunity to serve another term. So thank you for your attention, and I am happy to answer any questions that you might have.
Thank you very much, Judge Raimundi. Thank you in particular for the 7 years of service you've given to the state and all of the good works that you did in your volunteer capacities before that. Very much appreciated. And thank you for the explanation of what it is you do every day. I will now open it up to committee members for questions. And the first hand that I see raised is Representative Reckitt. Go ahead, Representative Reckitt.
Thank you. I'm interested that you serve in the West Bath Court. When that court was being built, I was in charge of the domestic violence program that covered that court until it got transferred to the program that covers it out of Rockland. But so I was in the court a fair amount, saw the clerks quite a bit in the very beginning. And what you report as the collaboration with the parts of the system is encouraging, because in the early days it was hard, I have to say. And I think that there's been a lot of work done in West Bath, both before and during your time, that has made things better for particularly protection from abuse cases, which is the ones I was most familiar with. I think my question to you is on the functioning of the court system. You're not a sole provider. There are how many other justices in that jurisdiction? I heard you say.
Are you talking about? Are you talking West Bath, or are you
yes,
talking?
Yeah.
Well, right now, I'm the sitting judge in West Bath, and during these COVID times, well, first of all, we're down some judges. As you know, you as a committee have just sat on some recent nominations, and so I think that they're still in training. So pretty much, I'm the district court judge that's mostly here in West Bath. Once a month for a week, we have active retired Justice Field here, Judge Field here. Other than that, it's just been me. I'm sorry, did I misunderstand your question?
No, that's fine. That's what I wanted. Yeah, Judge Field was the sitting judge when I was active up there. So I've known him for a long time. I also know that you never called him Judge Fields if you want to ever speak to him again. He's very particular about his name. So he trained me well. I'm interested in your discussion about family matters, because I'm well aware of how difficult it is when a family matter gets strung out, as long as they sometimes have done this past year. My wife and I have a daughter who has been strung out for the last year with a divorce that has sort of put a stop on her life entirely. So I'm very happy that the courts are starting to move towards resolution in the backlog of cases, of which she's one, not in your area. She's in a wildly different district. But I think that I was interested to hear your talk about the domestic violence court, which is really a update from the defendants as to what they've been doing to try to carry out the orders of the court and to change their lives. Mary O'Leary is with the Volunteers of America batterers programs. Is that true?
She is, but she's doing the certified batterers programs. So she's during COVID, she's been doing it. I think she's been doing a telephone check-in. And it's the DV courts are different all over the state. I know that there are some areas of the state that have just completely suspended the domestic violence courts, and they're not. They've just not been doing anything. But the consensus down here was that we wanted to keep in touch and keep the program going. And all of those people that I mentioned were on board with keeping the program going. And so they check everything from, are they paying their child support? Do they have financial issues? Are they going to counseling? Are they participating in their substance abuse programs? Have they had any more criminal offenses? They're really on top of people. And there are regular check-ins, and there are regular check-ins with the court. And you get to know them because a lot of them are in the Certified Batterist program, which is a 48-week program. And so if they're coming back once a month, you get to know, some of the details of, somebody got a job and he is working as a supervisor at Dunkin' Donuts, and how's that going?
Yeah.
So.
Anyway, thank you very much. The only other thing I wanted to say is my guess is that the woman with the elephant was from Hope, Maine, which I think is in your jurisdiction. So anyway, I appreciate the difficulty of that particularly unique excuse for getting out of jury duty.
As I said, how can you not like this job? There's always something new.
Right.
Thank
That's
you.
why I worked so many years in the domestic violence arena. It was always no 2 days were the same in 37 years. So it really made a difference.
So Representative Reckitt, when you were talking about that, I think you were talking about maybe the precursor for New Hope for Women.
Well, that area used to be covered by Family Crisis Services out of Portland. And then the Department of Human Services transferred it up to the Rockland jurisdiction. So.
And now it's covered by New Hope for Women, and they are there at every single protection from abuse hearing date. And
good, I'm glad to hear that.
I love to see them walk into the courtroom. Thank you very much.
Thanks.
Thank you, Representative Reckitt. And it's good to know that sometimes the elephant in the room is really an elephant in the room.
Yes.
I would now turn to Representative Babich.
Thank you, Mr. Chair. Good to meet you, Judge Raimondi, and I'm very impressed with your background and so forth. You said your resume revealed a very elite educational background, which I admire very much, and your comments show that I still think you approach your job with a great deal of humility and empathy. You mentioned being the only woman in a group that was nominated by Governor LePage and the only non-prosecutor, if I recall, in that particular small group. And I just, when you and I were, well, actually I'm a little older, but getting out of school, going into college, I remember there were about 4% in 1970. I think 4% of lawyers were women. I just wanted to ask you a basic background question. When did you get interested in the law? Was it another impressive hill to climb, or did you have any particular reason for deciding to?
Well, it's kind of a funny story, but it's a true story. My husband decided to go to law school, and I had just finished at Brown, got my master's at Brown. So he applied to Boston University and got into Boston University Law School. I was working to put him through law school. He used to say to me, you should do this, you'd be good at it. And it really wasn't an option because at that time, I was working to put him through law school. Besides which, and again, this is true, if I couldn't go to sleep at night, I'd ask him to talk to me about law. And it was like the instant soporific, I'd be asleep in 2 seconds. So one Saturday morning, he woke me up and said, "You've got to get up." And I was kind of cranky about it because it was the weekend and that's the time that I had off. And I was a little resistant to it and said, "Why do I have to get up?" And he said, "Because I signed you up for the LSATs." And he gave me 2 number 2 pencils and he walked me over to where the test was taking place and gave me a package of M&Ms and I took the LSATs. And so that's how I got to law school. It was not a lifelong plan. Let's just put it that way.
Fascinating. Thank you for that. Thank you, Mr. Chair.
Thank you, Representative Babich. Are there questions from other committee members for Judge Raimonde? Seeing none, again, I want to thank you for being here today. It was very interesting to hear about your experiences as a judge, and I can see why you have no idea what to expect every day when you walk into the courtroom. So thank you very much.
Thank you for your attention.
I will now take comments from persons attending this hearing who wish to speak for or against the nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement to the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to panelist status in Zoom, and they will be able to be seen and heard. When it is your turn to speak, please observe the following rules. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from members, you'll be returned to attendee status and the next person will be called. I have a list of people that have been signed up, to speak, and I will go through them in the order that I have and ask the committee clerk as I do that to move them from attendee status to panelist status. And the first has already been promoted to that status, and that is Megan Burbank. Ms. Burbank, when you're comfortable, please unmute your mic and turn on your camera and begin to present your testimony.
Thank you, Representative Harnett. My name is Megan Burbank. I am a resident of Jefferson. I have a law firm in Boothbay Harbor, Maine, Barry and Burbank. And I'm pleased to speak in favor of Judge Raimonde's renomination this afternoon. I really appreciate your time. Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee, Judge Raimonde just told you in her responsive comments that she had learned patience, respect, and an open mind during her 7 years as a judge so far. And with all due respect to Judge Raimonde, I would have to say that I disagree with her as to the impact of her learning that in 7 years. From my experience, I've seen 7 years already of patience, respect, and an open mind. So her base level of education on that in her perspective is quite different from mine. I'm very impressed with all three of those qualities that Judge Raimonde has. She delivers consistency. It's very, very important for attorneys practicing in front of a sitting judge to be able to know what to expect. And I greatly appreciate Judge Raimonde's consistency in the delivery of her decisions and in her demeanor in the courtroom. Having a good idea of what a sitting judge will decide helps attorneys to guide their clients towards settlement when appropriate. It also allows us to prepare our clients for what it will be like to appear in front of a particular judge, because every judge, of course, has a different feel, and clients can have a different response to different judges. So we need judges. So we need to be able to prepare our clients for these things. There are a few character traits that appear to be natural for Judge Raimonde and really enhance her ability to preside over a courtroom. She does not lose her temper. You've heard her today. Her voice isn't abrasive, loud, but it is confident and it commands respect. When an attorney or litigant during a court hearing steps too far out of line, Judge Raimonde's cadence slows, the volume of her voice drops. That litigant might be yelling, they might be out of control. This really does happen in the courtroom. And somehow, perhaps because of her poised facial expression or the line of her jaw, maybe the look in her eyes, It just takes a few moments for that courtroom to become very, very quiet. Then even the people who have stepped out of line, they literally lean in to hear what she says. With that, she's gained control of her courtroom, and she has everyone listening to her. It's a fantastic ability, and it's a good lesson for both the lawyers practicing in front of Judge Raimondi and the litigants to try, those of us who try to use brashness and volume of our voices and interruption to impact the others around us. It's a good lesson to these people that authority is derived from self-control, from a calm and reasoned response, and well-chosen words and timing, rather than from brashness and loudness and interrupting. Judge Raimondi is fastidious with her case preparation and time management, no matter what type of case she's presiding over. We know how the case will go during the day, how long the case will last, usually when we'll be getting our breaks. She'll have reviewed your file. She'll know all the names of the children in a child protective case or in a family matter case. And if there's an obscure legal issue, she will already have taken the time to do some research so that she's not behind the game when she starts her hearing. It's really not, that doesn't always happen, and it's really helpful when it does. Judge Raimondi decides her cases in a timely manner. Her decisions are detailed and precise. It's very difficult to have a client that has that disconcerting feeling at the end of a long, say, 3-day hearing. And you have to answer all these questions that your clients ask you, including how long it might take for the judge to make a decision, and will she answer all of our questions? With Judge Raimondi, I can always say, yes, she will answer all your questions. It will not take long to get a decision, and you will know why she made that decision, whose testimony she believed, whose testimony she discounted. The specificity of her decisions is very, very helpful. It's very helpful, especially in family matters and in child protective cases, because those types of cases sometimes come back around to the same judge, or at least to the same court. And so if we have a client who needs to know what to do next, they have a very detailed decision. They can change the things that need to be changed and improve upon the things that she points out as are their strong points. On a personal level, Judge Raimondi is a real pleasure to work with. Sitting in her chambers with her and other attorneys when we're conferencing cases is very pleasant. She's always respectful. She is congenial to all, no matter if she's known you for 7 years or is just meeting you. That's your first time in front of you, or in front of her, excuse me. She has a great sense of humor, and I know her for her occasional well-timed cynicism, which I also enjoy very much. She has a couple projects that she's worked on in Lincoln County. I am the president of the Lincoln County Bar Association, and she has really stepped up her effort, or put in a lot of effort, to make sure that our Bar Association is expanding, is staying alive, and she's been very supportive in that, giving her time, helping us present CLE, continuing legal education programs, and giving up her time in making some of those presentations. That's very appreciated by the Lincoln County Bar, and I know that she continues to do that type of work. One additional type of public service that she's been involved in is the Courthouse Assistance Project, which helps family matter and other small civil cases by having volunteer attorneys come into the courthouse. You sign in, and the Volunteer Lawyers Project sort of sends your clients into you. You give them legal advice for about 15 minutes, and off they go, hopefully with a new understanding of what their steps are. And so she brought that, helped to bring that program to Lincoln County. It was in West Bath, and it hadn't gotten to Wiscasset yet. And she was instrumental in doing that. Also a great service to many, many litigants who did not have the funds or access to legal representation. I really appreciate the opportunity you've given me to speak in support of Judge Raimondi's renomination. I don't practice as often in front of Judge Raimondi now, as I did when she was sitting in Lincoln County in Wiscasset. But it's always a joy to do so when I'm able to be down in West Bath. I have no doubt that the consistency that she demonstrated in Lincoln County is also demonstrated in West Bath. And I request that and hope that you all support her re-nomination for her district court judge position. I will also welcome any questions that you may have of me regarding Judge Raimondi. Thank you.
Thank you very much, Ms. Burbank. The committee certainly appreciates you taking the time out of your day to offer your insights and observations on the nominee. Are there committee members that have a question for Ms. Burbank? There's something to being said for having hearings in the afternoon. You're off the hook at this point. Thank you very much for taking the time to present to us. The next person that I have on my list is John Healy. If we could bring John in, Mr. Healy in as a panelist.
Good afternoon. My name is John Healy. I live in Camden, Maine.
Welcome, sir. Thank you.
Thank you. It's a privilege to be here today. Senator Carney, Representative Harnett, members of the committee, thank you for allowing me the time to appear before you to present testimony and to fully support and endorse Judge Barbara Raimondi. I am sort of, we talked about elephants a couple of minutes ago. I'm sort of the dinosaur. I have a corporate background. I retired after 37 years from a corporation down in Connecticut. I retired up to the beautiful state of Maine. I had nothing to do. I looked for something and I found out about the guardian ad litem program. I went through the training. I didn't have any cases to work on, so I was waiting for the phone to ring. My first guardian ad litem assignment happened to be with Judge Raimondi. It was a very, very difficult case, but I went into this process not knowing anyone in the bar, certainly not knowing the judge. I had the basic training, but that was about it. So it was certainly a baptism by fire, and I learned a tremendous amount in this case. The case that I was appointed to, it took a million twists and turns. Ultimately, it lasted almost 2.5 years. It was appealed to the law court. The law court appealed Judge Raimondi's decision, and it was the couple of documents I hold on to, and that was one of the decisions that I carry in my special file. So as far as Judge Raimondi's in-court demeanor, I think you've heard Attorney Burbank explain precisely what's going on. I, as the guardian ad litem, have appeared before Judge Raimondi probably 40 times, maybe more, each as a guardian ad litem, each with a different case and perspective on what's going on. But we talked about consistency. There's absolute consistency and predictability among the members of the bar when you're appearing in front of Judge Raimondi. She is infinitely fair. She's respectful, which I place a premium on. I like to use the word grace in describing Judge Raimondi and her demeanor. And that's just the beginning when you go into the court. You're also wowed by the breadth of her experience. She's seen all these cases. She's seen very, very difficult and crazy cases, but she remains calm. She remains cool. And she talked about being respectful. And I think that's a huge part of what she does. She's also just an excellent attorney. She's an excellent jurist. It's always a pleasure to appear in front of her. And I have the opportunity as a guardian ad litem, and people tell me stuff all the time, whether it's other attorneys or parents who are appearing before in child protection matters, and it's consistently they're absolutely impressed by her abilities. From a corporate standpoint, I place a lot of value on efficiency, and I know of no other court, and I appear in about 10 different courts as a guardian and as a parent's attorney, but I've never seen a more efficient judge. And I sent a letter in supporting Judge Raimondi, but in one particular case, it was a very complicated family matter. A lot of things involving ESOPs and financial planning, and if actually almost a full day hearing within 36 hours in the U.S. mail, which is unbelievable. I received a 20-page opinion, which I thought was thorough. It's a pleasure always to read decisions from Judge Raimondi. And I thought it was spot on. So I just was amazed at the efficiency. And it wasn't just that case. It's, whether it's an interim hearing and it's a quick order, it's in the mail within, the next day or so. So I can't say enough about Judge Raimondi. I think she's absolutely well qualified to serve another 7 years or another 21 years or whatever if you can extend the limits, that would be fantastic. But I can't say enough about her abilities on the bench and her personal integrity and her command of legal skills and people skills. With that, I'd be happy to answer any questions.
Thank you very much, Mr. Healy. And I know I appreciate, I know the members of the committee appreciate you taking the time out of your day to share your observations and thoughts with us. Much appreciated. Are there questions from any committee members for Mr. Healy? Seeing none, again, thank you very much for your time, sir.
Thank you.
Greatly appreciated. The next person I would ask to be moved over as a panelist is Virginia Davis. And Ms. Davis, when you're ready, if you could unmute yourself and activate your video and begin as soon as you feel comfortable.
Thank you, Representative Harnett. I had not intended to testify. I did send in a letter in support of Judge Raimondi, and I can only emphasize everything that you have heard from your other witnesses. I would point out that as I thought she was a past president, maybe she was only president-elect of the Bar Foundation, now the Justice Foundation. She is keenly aware of the needs of unrepresented people, and she knows how to deal with that, and she knows how to be fair, and she knows how to be balanced. You've already heard that she's intelligent. She has the highest integrity. She's fair. She has equanimity. She's conscientious. She's committed to her job, and she's diligent. I can't think of a better person to serve Maine and be a judge for Maine people. I am a past president of the Maine State Bar Association, and as such, I'm familiar with confirmation hearings, and I'm familiar with one of the more critical elements of a judge, and that is judicial temperament. Judge Raimondi has it in spades. She is dignified, she is respectful, she is calm, she is courteous. I highly recommend her for reappointment. Thank you. Thank you for your attention.
Thank you very much, Ms. Davis, and I'm sorry to startle you with pulling you up as a panelist. It might have been a flashback to law school, but you did very well.
Oh, well, thank you.
Okay. Are there any questions for Ms. Davis from members of the committee? Seeing none, thank you again for sharing your thoughts with us, and I will now turn to Susan Fonts.
Good afternoon, members of the Judiciary Committee. My name is Susan Fonts, and I am the president-elect of the Maine Trial Lawyers Association. I'm here today to testify on behalf of our association to strongly support the Honorable Barbara Raimondi for her renomination to the Maine District Court. Our members rated Judge Raimondi highly for her judicial temperament, skill, and demeanor. Respondents to our survey called her an excellent judge and truly a great person, saying that it is always a pleasure to appear in her court. Another respondent called Judge Raimondi thoughtful and sensitive to the needs of different litigants. Additionally, someone said that she has the perfect character and demeanor for a district court judge. These comments echo the high marks that Judge Raimondi received for her private practice when she was surveyed for her initial appointment in 2014. In evaluating these surveys, our executive committee noted her leadership skills. She has shown her commitment to access to justice by serving as the president for the board of Pine Tree Legal, and she continues to show that commitment as chair of the Cadres Committee as a judge. Based on our high evaluations by our members and her demonstrated leadership skills, I am proud to endorse Judge Raimondi reappointment to the Maine District Court. We believe her reappointment brings honor to the bench and to the people of Maine. I'll be glad to take any questions.
Thank you very much, Ms. Fonts. And again, thank you for taking time out of your day to share your observations and that of your organization with the committee. Very much appreciated. Are there questions from any committee members for Ms. Fonts? Seeing none, again, thank you very much. We appreciate you taking the time out of your day. I believe I have one more person to testify, though I will check with the attendee room after he is done, but that would be James Cohen on behalf of the Maine State Bar Association. Mr. Cohen?
Thank you, Mr. Chairman and members of the committee. My name is Jim Cohen. I am an attorney with Farrell Dana, and I also serve as legislative counsel for the Maine State Bar Association. You probably heard this morning from our president, Kelly McDonald. He passes along his regrets that he cannot join you all this afternoon. This happens to be when the Board of Governors is meeting. So he asked if I would present to the committee. You all should have his letter in your file, but I will simply say, as I think this committee is aware, our association has a regular practice of conducting a survey of our members, and we have 3,000 members, and we survey them for judges who are in their 6th year. And so we had that opportunity to survey our members on behalf of Judge Raimondi. And we're very pleased to say that we strongly support the renomination of Judge Raimondi here today. And I wanted to share, we've heard some adjectives already that describe how she conducts her courtroom, and I'll share a few more from our members who describe her as being compassionate, thoughtful, and a fair jurist. They describe her as intelligent, attentive, courteous yet firm, as well as patient. They have described her as well as being providing well-reasoned and timely decisions, that she has good knowledge of the law. She's efficient and effective in her management of the docket. And that seems very consistent with all of the testimony that we've heard here today. So we're very pleased to support the nomination before you, and I would be more than happy to answer any questions that you have. Thank you very much.
Thank you very much, Mr. Cohen, and thank you for filling in for Mr. McDonald this afternoon. We appreciate your time. Are there questions from any committee members for Mr. Cohen? This is not usual behavior from this committee, but thank you very much for being here. Mr. Cohen, we really appreciate your time. I'm going to take one last look in the attendee room and ask that if there's any person in that room that does want to be heard on this nomination, to please raise your electronic hand. And Ms. Panett, I am not seeing anyone. Is that accurate on your end?
That is correct, Mr. Chair. There are no longer any people in the attendee that will be speaking today.
Thank you. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. Are there any, Ms. Panett?
There are none, Mr. Chair.
Thank you. We will then vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice of nomination, and we are within that timeline. The hearing by the Joint Standing Committee on Judiciary for the Honorable Barbara L. Raymonde of Brunswick for reappointment as a district court judge is now closed. We will proceed to taking the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. Therefore, at this time, I will ask whether any member present objects to proceeding to take the vote immediately. If you do object, if you could raise your electronic hand or wave your physical hand on the screen. And I am not seeing blue hands or real hands. So there is no objection, and we will take the vote immediately. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Barbara L. Raymonde of Brunswick for reappointment as a district court judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? I would ask the committee clerk to call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Thank you. Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. I have 12 members voting in the affirmative, 0 in the negative. 2 are absent.
Thank you very much, Supi. 12 members of the committee having voted in the affirmative and 0 in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Barbara L. Raymonde of Brunswick for reappointment as a district court judge be confirmed. Congratulations, Judge Raymonde. Were we in normal times, we would all get up and offer our personal congratulations and thanks to you for a second term. Because we are unable to do that, we do engage in some virtual applause, and please take that with our thanks for the work you've done and the good work that I know you will continue to do in the future. Congratulations.
Thank you, and thank you for giving me the opportunity to continue to serve. I really appreciate it, and for your time and attention today.
You're very welcome. Committee members, we have another hearing beginning in 22 minutes. If we could all be back maybe a couple minutes before 3, so we could start right on time with our final confirmation hearing of the day regarding Judge Andrew Benson. As a reminder, if you are, the stream will keep running, so please mute your microphones and shut off your video. and I will see you all in about 20 minutes. Thank you.
Last one.
Yes, sir.
Good afternoon, Representative Harnett and Mr. Hobbs.
Good afternoon, Judge.
Good afternoon, Judge. Nice to see a former colleague in such an important position.
It's a pleasure seeing you in a much more important position.
We can squabble on that one, but I'm okay. It's good to see you.
It's a pleasure to see you.
And the family is well?
Very well. How's your sister doing?
She's happily retired.
Is she? Good, I'm glad. I know her husband is as well.
Yes, but I think he's happily retired and busy.
Well, that probably is.
We're supposed to start up at 3. I'm going to wait for other committee members to join us. It's the problem with the break is people forget they have to come back.
Well, it is the end of the day. There are both advantages and disadvantages, I think, to being at the end of the day.
Hi, Judge Benson. I just want to introduce myself. I'm Ann Carney. I don't know that we've met, but it's nice to see you.
Probably have not. It's a pleasure to meet you, Senator Carney. I don't think you were on the committee. I think the only holdover from my previous hearing was maybe Representative Moriarty, I'm thinking.
Yeah, I think he's doubled up on quite a few.
Yes. I probably shared this with some of my committee members. I went to Catholic grade school, high school, and college. So 3 o'clock means, 5 to 3 for me.
Perhaps your committee members didn't go to Catholic school.
They seem very well balanced. That might be the case.
Must have been the Jesuits.
Yeah.
I had the Jesuits in college.
In the Air Force, we called that Lombardi time.
Okay, it looks
Some
like
of us didn't have our video on, but we've been listening for 5 minutes at the desk here.
I know something about loose lips. I should just keep quiet till we're going to start up again.
Judge Benson, Chris Babbage, glad to meet you.
It's a great pleasure to meet you.
I came on the judiciary the next term after you were confirmed last time.
So 2015, 2016? Or?
Yes.
Yeah.
Elected 14 for 15 and 16, right?
Nice to meet you, Judge. Today's my first day on judiciary.
Well, congratulations. It's a pleasure meeting you.
Take all spectrums, right?
That's right. I think I saw part of Justice Mullen's hearing this morning. I think you came in after having been at another committee meeting, perhaps. But
yeah, yes.
Give it another minute or two. Okay, it is now 3 o'clock. Welcome to the fourth and final judicial confirmation hearing in front of the Judiciary Committee today. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the Governor of the Honorable Andrew Benson of Athens for reappointment as a district court judge. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendation to the President of the Senate. Today, the committee will hear testimony from and have an opportunity to question the governor or her representatives, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant or panelist in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and will be available at the end of the day on the committee's YouTube channel. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Poirier for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Andrew Benson of Athens for reappointment as District Court Judge.
Thank you, Representative Poirier. And do I have a second? I would call on Representative Sheehan.
Thanks, Mr. Chair. I second the motion.
Thank you, Representative Sheehan. We have a motion by Representative Poirier and a second by Representative Sheehan, so we will proceed. A copy of the statutory requirements for the position of District Court Judge. A copy is available electronically and was part of the notice of today's hearing. At this point, I will now recognize Jerry Reed, the Governor's Counsel, making a statement concerning this nomination. Mr. Reed, welcome to the Judiciary Committee.
Thank you. Good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this afternoon to speak in support of the nomination of the Honorable Andrew Benson of Athens for reappointment for the Maine District Court. Judge Benson holds a degree in German with highest distinction from the University of Maine at Orono and is a graduate of the University of Maine School of Law. After law school, he spent 5 years as an assistant district attorney, trying cases in both district and superior courts in Augusta and Skowhegan, including over 100 jury trials. He then worked for 2 years in private practice, again focusing on trial work in the context of family law and criminal defense. He returned to the DA's office in Somerset County for 2 years in 1996 before accepting a position as a senior homicide prosecutor in the Attorney General's office, where he served from 1999 to 2014. Judge Benson was appointed to the Maine District Court in 2014. And since then, he's presided primarily in the Skowhegan District Court, but also occasionally in Waterville, Augusta, Bangor, Newport, Lewiston, Portland, Holton, and West Bath. He's a dedicated and hardworking jurist whose record fully supports reappointment to a second term. On behalf of Governor Mills, I ask for your support for the nomination of the Honorable Andrew Benson of Athens for reappointment to the Maine District Court, and I would be happy to answer any questions you may have. Thank you.
Thank you, Mr. Reed. We appreciate you being here today and thank the governor for putting this nomination forward. Are there questions from any committee members for Mr. Reed? Seeing none, again, thank you very much for being here for all 4 of our hearings today, and I have a feeling we might see you tomorrow morning.
Indeed, I look forward to it.
I would now turn to John Hobson, who chairs the State of Maine's Judicial Selection Committee. Welcome back, Mr. Hobson.
Thank you very much. Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee. On behalf of the Judicial Selection Committee, I request that this committee act favorably on the renomination of Judge Benson. Judge Benson came to the position of District Court Judge after having a really stellar and distinguished career in criminal prosecution. He had a statewide practice of prosecuting some of the most complex criminal cases the state has seen. And he had not had, although had some in private practice, had not had that much experience in the other civil areas. But one would have thought that given his intelligence and ability to master the criminal field, it would not be that difficult a task for him to master the other areas of the district court practice. And that has proven to be the case, unsurprisingly. He has been able to pick up the other areas of law that the district court has within its jurisdiction, and mastered them and done an exceptional job. He's also, because of his experience in terms of prosecution experience, which candidly, there aren't a lot of others in the state that had that experience, really, maybe none. Brought that to the district court. When he's come to the district court, he's been able to bring the talent of criminal prosecution experience and do, I think I saw it was about 15 to 16 jury trials as part of the consolidated criminal docket. That's important. And there are two aspects of that I want to discuss. The first is, whenever someone who has had a career in prosecution comes to the bench, one of the aspects that the Judicial Selection Committee looks at in terms of reappointment is, have they been able to basically, when they went on the bench, change their perspective so that they are now the perspective of a judge, not a prosecutor. And Judge Benson has done that. Judge Benson has support throughout the defense bar as well as the prosecution bar, because the same intelligence and skills that he brought to his job as a prosecutor, he has brought to the job of judge on the district court, and clearly understands the role of a district court judge, and is done, and is not only how he thought of is, but is actually hoped for by criminal defense attorneys because of his knowledge of the criminal law and his willingness to have an even-handed approach to the application of that. And so that aspect of it is, as one expected when he was originally nominated, he has really done an exceptional job. The other aspect, if this committee were to act favorably on this request, and the Senate were to confirm Judge Benson for a second term, I think Judge Benson brings some skills that are going to be needed in the post-COVID-19 world. The reality is there is going to be a tremendous backlog of cases to be tried. As heroic as the judicial branch is trying to, efforts are in trying to basically keep the workflow going, the reality is, in the current situation, it is very difficult to have jury trials. Criminal and civil are basically non-existent. There is likely to be a need for a number of jury trials in the criminal context to basically clear up the backlog. This in turn will alleviate the backlog so that the civil jury trial backlog can be reached. And Judge Benson will bring to that process, as a district court judge, the ability to help clear that backlog. And candidly, as everybody who's a lawyer knows, that if you create a process where the trials are occurring, that the plea in the criminal process, the plea negotiation process is greatly enhanced when everyone is facing a trial date. And so that Judge Benson's past work has been exceptional, and the talents he now brings to the job become in some ways even more important in this potential post-COVID-19 world. And so with all of that, on behalf of the Judicial Selection Committee, I request that this committee act favorably on Judge Benson and allow him to continue to serve the people of the state of Maine as he did before in his career as a prosecutor and with the Attorney General's office. And with that, I'm happy to answer any questions.
Thank you very much, Mr. Hobson. Are there any questions for Mr. Hobson from members of the committee? Seeing none, I know I've said this before, and as I Senator Carney this morning, I do want to thank you very much. You're here all the time on these, and your volunteer efforts in running the Judicial Selection Committee do not go unnoticed. And I thank you on behalf of the committee and the people of the state of Maine for your time in this important endeavor. So
thank you very much. And since we're at the end of the afternoon, I'd like to thank this committee for spending the entire day in a Zoom process looking at little boxes while the outside temperature actually hits June-like levels, it looks like. But thank you very much.
Well, we're all going to come over to your house for a socially distanced dinner and to enjoy that nice weather. But so thank you for that. I now recognize the Honorable Andrew Benson for the purpose of making a statement concerning this nomination. Judge Benson, welcome to the Judiciary Committee.
Thank you very much. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary, I am both pleased and humbled to appear again before this committee, having been renominated by Governor Mills to serve a second term in the Maine District Court. I'd like to thank Governor Mills for entrusting me with this responsibility, as well as for the graciousness that she has always shown to me throughout both her career and mine. 7 years ago, when I was first nominated, she was kind enough to testify in support of my nomination, and I sincerely appreciate that gesture, as well as her decision to renominate me now for a second term. I would also like to thank Jerry Reed, the counsel for the governor, and John Hobson, the chair of the Judicial Recommendation Committee, for introducing me. Jerry and I worked together at the Attorney General's office at the same time, but we were in different departments and we certainly didn't know one another well. I don't really know John, but I appreciate both of their help in guiding me through this process for a second time. I would also like to thank the members of the committee for taking the time to meet with me this afternoon. It's certainly a pleasure and a privilege for me to meet with you. An equal privilege, which I feel obliged to acknowledge, is my family. I have been married to my wife, Alicia, a native of Argentina, for 31 years, a period which has been the greatest blessing of my life. She is certainly the love of my life, and I could have accomplished little or nothing without her constant help and support. We have another abiding blessing, our daughter, Unjae, whom we adopted as a 5-month-old infant from South Korea in 2002. Unjae is currently an 18-year-old sophomore in college who may be ill-advised enough to follow her father's career in law, even though her mother advocates that she follow her maternal grandfather as a neurosurgeon. Whatever she decides to do, she's certainly a blessing and a delight for her mother and for me. Some of you are now somewhat familiar with my background. Before becoming a judge, I was, for the most part, a career prosecutor. For the last 15 years of my career, before I came on the bench, I worked as a senior homicide prosecutor in the Office of the Attorney General, where I had the pleasure of working for Attorney Generals Andrew Ketterer, Stephen Rowe, Bill Schneider, and of course, then Attorney General, now Governor Janet Mills. While I was in the Attorney General's office, I tried literally dozens of murder cases in every superior courtroom in the state, with the odd exception of Franklin County. However, I did try at least one murder case everywhere else, and in most cases, I tried many. I made an effort to learn my craft well, the craft of trying cases, how the rules of evidence worked, and generally how a case gets through the court process. At least I hope I did. I have a distinct recollection of appearing before this committee 7 years ago, almost 7 years ago to the day. And many of the things that I told that committee, I would repeat today. Then, as now, I suggested that courts cannot solve every problem or right every wrong in our public life. Most critical public policy decisions and value judgments must be made by the political branches of government, elected by and accountable to the people. Courts must always enforce the rule of law embodied in those policy decisions by accepting the law as we receive it from the Maine legislature and the Maine Supreme Judicial Court, regardless of whether we agree with it. Enforcing the rule of law is critical to a free society. When the courts do act to resolve a dispute, they have to do so both swiftly and fairly, and they have an obligation to treat the parties involved in the dispute with impeccable courtesy. I told this committee 7 years ago that I think that it's the responsibility of the judge to try to be the politest person in the courtroom, and I still would hold by that, although I will admit that my patience has been stretched to the limit on more than one occasion over the last 7 years. However, with that being said, I recognize that going to court is almost always a stressful experience for the litigants, particularly in the district court, where so many of the parties are representing themselves, and the judge has to bend over backwards to act with courtesy, humility, and respect. People aren't always going to remember exactly what you said or wrote in deciding a case, but they will remember how you treated them. I have developed over the course of my career, particularly my judicial career, a theory about what justice is. And the theory is really very simple. Justice exists when the court follows and requires that the parties follow the rules. Justice is, in many respects, tantamount to process, and it exists when the court applies the correct law, determines the credibility of the witnesses, and ultimately decides whether the plaintiff or moving party has carried his or her burden of proof. Judges are almost never at the scene of a crime or a dispute. We're certainly not omniscient. We are not gods. So we do our best to provide justice by providing a fair process. And in doing so, we must not substitute our judgment for that of the political branches. We have, as I noted before, an obligation to apply the law as we receive it from the legislature and the Supreme Judicial Court. We are ministers of justice and behave as we should if we, just like everyone else, follow the rules that we are given. I come before the committee today with humility about the responsibility of the position for which I've been renominated. I have thoroughly enjoyed my first 7 years as a judge in the Maine District Court, and I would appreciate it if the committee would repose its trust in me again for a second 7-year term. Thank you all very much, and I would be delighted to entertain any questions that you might have.
Thank you very much, Judge Benson, and thank you for your service the past 7 years and your service on behalf of the state before that time. Are there questions from committee members for the nominee, Judge Benson? Seeing Representative Moriarty. You might be on mute, Representative.
I was. Thank you, Mr. Chair.
But
Good
now
afternoon, Judge Benson. We met, I think, 7 years ago at your initial confirmation hearing.
I think we did. I think I mentioned that before the hearing. You were the only holdover from that time.
Okay. I'm just curious, given the demands of your career, have you been able to maintain your skills in German?
They're not quite as sharp as they were, but I think I could still get by if I had to.
I can barely get by, so you're well ahead of me.
I did have a small claim a couple of years ago where one of the parties, the plaintiff or the defendant, was German or Austrian, and we spoke some German. So,
well, congratulations on choosing an interesting and demanding major.
Thank you.
Okay, thanks very much.
Thank you, Representative Moriarty. Representative Evangelos.
Thank you, Mr. Chair. I think Lois was next.
Okay. Representative Reckitt, then Representative Evangelos.
I always like to take my hand down first, or I forget. Judge Benson, I'm intrigued that you're from Athens, Maine, and the reason I'm intrigued by that is that I recently hired one of the best contractors I've ever contracted with in my entire life, who happens to live in Athens, Maine, and is commuting to South Portland to do contracting at my house.
Oh, no
so
kidding.
Bless you for in doing that. Anyway, my question to you has to do with the courts up in your jurisdiction, which I'm particularly concerned about because I know how difficult it's been for them to operate in the current climate. And I'm curious as to your projections as to how particularly the family court arena is going to come out of this pandemic, and how you're going to catch up with the caseload in the courts that you service up there.
Thank you for the question, Representative Rackett. It's interesting. The worst part of the backlog isn't really in either the child protective arena or in family cases. Those have slowed down a little bit. The worst part of the backlog, certainly in our court, and I think something that's been borne out by the studies done by the judicial branch, is in criminal matters. And that is largely because we haven't had an opportunity to have jury trials, and exposure to trials settles cases. As I think someone noted in the last confirmation hearing, I think with Judge Raimondi's confirmation hearing, we've been given, because the Superior Court justices have been more or less concentrating on criminal cases, district court judges have been doing a larger amount of trailing docket time, which means we've been able to devote an extra 3 or 4 days a month per judge, both to child protective and to family matters. And so for that reason, I won't say we're caught up, and I won't say we're not a little bit behind, but we are not nearly as badly behind as we might be. And it's been because we have devoted additional time to both family and child protective cases.
That's good to hear. I knew that there was a trailing docket going on up there in family matters. I won't tell you why I know that, but I do know that. And I think it's encouraging that you think it's moving forward at this point. Thank you for your interest in the arena. Has your experience with family matters in the arena where you practice as a sitting judge, is it different in that area of the state than it is in other areas? Have you done any other practice in different areas other than homicide?
I have sat in a number of the different courts that were mentioned either by Mr. Reed in his opening remarks. I've sat in Holton, I've sat in Portland. And as you might imagine, Somerset County is one of the poorer counties in the state. So the family issues that the court has to resolve often are perhaps somewhat more intensely tragic, often involve more drug and alcohol abuse, I think, than in some of the more affluent parts of the state. So I think it is different. It's obviously one of the most important things we do, dealing with other people's children in particular. But I think it is different because of the lack of affluence here in Somerset County.
Thank you.
Thank you.
Thank you, Representative Rackett. Representative Evangelos.
Thank you, Mr. Chair. Good afternoon, Judge Benson. I have a variety of questions I'd like to ask you today. The first one is, could you please articulate for the committee what your understanding is of the Brady Rule and which Supreme Court case it referenced?
U.S. v. Brady, dealing with, first of all, the requirement that exculpatory information be provided to criminal defendants and criminal defense attorneys if the state is in possession of exculpatory information. I can't tell you what year it came down, but that's my understanding of the rule.
And it was 1963, if that's okay. And how about the Giglio Rule? Same question.
Giglio Rule is similar, dealing with issues relating to impeachment of a law enforcement officer. For example, if the state is in possession of information that a law enforcement officer has behaved badly, has done something that would affect his or her credibility, then the state does have the obligation to turn over that information.
Recently, I came into knowledge regarding a case you prosecuted, the state versus J. Mercier. That was in 2012. Is that correct?
Yes.
You were aware, I assume, in 2012 that an employee of the State Police Crime Lab, Todd Settlemeyer, was separated from his employment because his genetic material was found on evidence in the DNA processing room, and he wasn't allowed in that room. Were you aware of that?
I'm not sure I was aware of it at the time of the Mercier trial. I have since become aware of it. There's what's called a post-conviction review hearing that's going on, that's being dealt with in the Attorney General's office. I have to apologize, Representative. It was 9 years ago, so I don't remember exactly the point at which I became aware of it. It may have been prior to the trial, or it may have been after the trial, but I am aware of it.
There was a 6-day trial in September of 2012. You wrote a memo on August 1st of 2012 from the Attorney General's office describing, it looks to me like an unsuccessful effort to solicit material from the state police in regards to Settlemeyer's misconduct.
It's possible.
Well, the problem is a man got sentenced to prison for 70 years, and the credibility of the evidence in the DNA lab at the state police had been compromised by an employee. This memo that you wrote indicated that, well, I'll read part of it. While the Office of the Attorney General has not been made privy to any formal report dealing with the sort of potential giglio material in connection with State Police Crime Lab employee Todd Settlemeyer, the office has recently been made aware of the fact that there may be such material. Don't you think that that would have been critical information to have during that trial and should have been disclosed to the defense?
Well, you'll have to refresh my recollection, Representative Evangelos, about the purpose of the memo that I wrote. I have a vague recollection of the memo, and I think it was to put the court on notice that this material could potentially exist so that the defense could seek the material. Again, I don't remember the exact ins and outs or the details of exactly what happened with Mr. Settlemeyer or whether that was disclosed, but clearly I was aware of it, and clearly I was trying to put the court on notice that it existed.
It was a memo. The subject matter says it was giglio concerns involving former state police lab employee Todd Settlemeyer. The state police refused to provide the defense or the court the information. And there's a Supreme Court decision, Kyle versus Whitley, 1995, which says that it's incumbent upon the state to release these kind of exculpatory information to a criminal defendant. It was a sort of a extension of the Brady rule. Aren't you concerned that the defense wasn't allowed to get information that could have led to the exoneration of their client?
I guess I would have a twofold answer for that. First, and this is not really part of my answer, I guess it's a prologue. I have to say, I don't remember all of the facts involved in that discussion at the point. I clearly was trying to put the court on notice that this information existed. And I remember that Justice Nivison presided over the trial. Justice Nivison, if I recall correctly, was aware of it and probably made some rulings about the extent to which the defense was entitled to get that information. I believe it was fairly thoroughly litigated. So I think due process was complied with, although I don't remember exactly what Justice Nivison did. The second part that I would point out is that there is an ongoing post-conviction review. It's been ongoing for some period of time. I know that Mr. Mercier is represented, I think, by Attorney Amy Fairfield, who may or may not be raising this issue. I think the state made a good faith effort to provide Mr. Mercier, who was represented by Attorney John Alsop and Attorney John Martin at the time. I think we made a good faith effort to provide them with the material, or at least to put them on notice that the material existed. So I think we complied with the duty that was placed upon us.
Well, the memo says that the counsel for the Maine State Police has declined to either confirm or deny the existence of any information or material regarding the giglio request. So my conclusion is that the state was not in compliance with Kyle versus Whitley because the criminal defendant was denied the possibility of exculpatory evidence. Certainly, if an employee of the Maine Crime Lab was in the DNA room and his DNA, his own personal DNA was found on evidence, wouldn't that lead any person to have concerns regarding the evidence that was submitted at that trial?
Yes, possibly, but I think the answer is more nuanced than that, Representative Evangelos. And by that, I mean, I don't think that there was any implication, and again, forgive me, because it was 9 years ago. I don't remember there having been any implication that Mr. Sutherland's DNA had arguably or possibly contaminated any samples of Mr. Mercier's. I know that it had been involved in other cases, or at least that's my recollection, but I'm not sure that there was any indication that it had been involved, or there was any indication it had been involved in Mr. Mercier's case.
Well, Mr. Mercier's case was occurring in September of 2012 when the state police conducted their investigation simultaneously with the process that went on in court. Their investigation of Settlemyer occurred during the prosecution and leading up to the prosecution of Mr. Mercier. Are you aware that the documents related to Settlemyer's misconduct in the main crime lab have been sealed?
I was not aware of that.
Well, they have been sealed, and that's part of the answer that you got back from the state police. So I don't see why you didn't have questions regarding this prosecution when clear evidence of misconduct occurred in the crime lab. This is documented. It resulted in the departure of the employee. He entered a DNA room where evidence was stored. Nobody knows exactly what he did other than that his own DNA was all over the place. This is according to information provided in an affidavit by Mr. Harwood, I believe of the Maine State Police. I'll quote now: Settlemyer resigned in 2012 during an internal investigation after his genetic material was found on evidence in a DNA processing room that he was forbidden to enter, according to a filing from Harwood related to a sex crime that same year. Settlemyer said he did not go past the doorway, but Harwood disclosed that Settlemyer went further into the room. So my concern is, as a prosecutor, the state's duty is to disclose this sort of exculpatory evidence to a criminal defendant. There wasn't much other evidence presented to the court in that case. The tire expert didn't come through. The only evidence you had was that Mercier had had sexual relations with the woman. Doesn't mean he killed her. And if we're going to have this understanding of Giglio and Brady, I'm really troubled by the lack of effort by the Attorney General's office and the state police in disclosing information to the defense and a criminal defendant, which is required under Supreme Court rulings, 3 of them now. And, you know, there's a man in prison for 70 years. It's fine to say it's under post-conviction review, but there wasn't that much evidence in that case besides the DNA, was there?
I would have to respectfully disagree with you. You said that the evidence about the tire tracks didn't come through, but nothing could be further from the truth. When the initial law enforcement officers arrived on the scene, they made photographs of the tire tracks, and there were 2 separate sets of tire tracks, which seemed unusual at the time because most new trucks, and my recollection is that Mr. Mercier's truck was a relatively new truck, one would expect that there be identical tires on both the front and the back. And in this case, it appeared that the tire impressions on the front and the tire impressions on the back were made from different kinds of tires. The tire impression expert, who was, if I recall correctly, Alicia Wilcox from the lab, testified about the fact that not only were they different tires, but that there were individual characteristics, as with fingerprints, individual characteristics that were consistent with tire impressions taken from Mr. Mercier's truck at the time in a garage in Madison. State police obviously did things very differently back in 1980 from what it's doing now and during my career there. But there were, not only were there different kinds of tire impressions, there were individual characteristics. In other words, they could say, yes, this particular tire, this tire from Mr. Mercier's truck made that particular impression. The other critical piece of evidence in that case was the stance of the truck involved, the width apart of the tire impressions. And the width apart of the tire impressions exactly matched the distance on Mr. Mercier's truck. We had I don't remember if it was a GMC or a Ford truck. I think it was a GMC truck. We had an expert fly in from GMC who testified that in fact, GMC had equipped trucks of that make and model with different tires on both the front and the back, and that the stance, the width apart of the tires was in fact consistent with Mr. Mercier's truck. So to suggest that the only evidence of his having caused her death was the evidence, the DNA evidence, I would respectfully disagree with you. I think there was abundant other evidence. I think your point about Giglio and Brady is well taken. I think we were making every effort to provide that information. However, as you know, Representative Evangelos, the state does not work uniformly. I have the obligation to provide information as a prosecutor that is in my possession. And I provided all information that was in my possession. I also made the court aware of the fact that there was information that was not in my possession that could in fact be exculpatory, so that the defense attorneys could go to the judge and ask the judge to issue an order, an injunction to provide that, to go to the state police to provide that. So I think I actually went above and beyond providing both the information that was in my possession and putting the defense and the court on notice that there could be other information out there of which or to which I was not privy.
Regarding your statement on the tire tracks, Alicia Wilcox was the expert, and her statement, and I'm quoting now, told the jury that she could not say that the tires for Mercier's truck actually made the tracks. Wilcox also said she could not tell when the tracks were made on the trail where St. Peter's body was found. So that contradicts what you just said.
Well, I certainly didn't say anything about when the tracks were made. I didn't recall her testimony about that. My recollection, and it may have been incorrect, was that she had said that there were individual characteristics consistent with having been made by Mercier's tires in particular. Perhaps she did not. I have not committed all of the evidence in that case to memory.
Well, specifically, she told the jury that she could not say that the tire tracks came from Mercier's truck. So regarding the Giglio and Brady disclosures, they certainly fall far short of the Supreme Court standards. And I know that in your opening statement, you said that the forensic, the DNA evidence was the forensic equivalent of pay dirt. And here you have a crime lab with contaminated evidence in the DNA room. I think, and I'm not a lawyer, but any reasonable person would be raising some pretty serious concerns and objections as to why the state didn't do more to disclose this exculpatory information. I don't understand it. I don't think you wrote a memo. And it looks to me like the memo has the state police stonewalling the request. And to this day, Settlemy's files are still sealed. We're not able to find out to the extent of how many court cases his misconduct could affect down the road should it become public. I do know that it did cause the courts at the time 3 criminal cases. The court required that the information regarding Settlemy's misconduct be disclosed to defense attorneys, but that was about it. That was about the effort the state made. So if we have sealed files regarding his misconduct, we don't know the extent to which the DNA evidence was contaminated. Admittedly, Harwood said he was in there and his DNA is all over the place. I just don't understand why that didn't raise concerns for you as a prosecutor as to whether you should have continued with that prosecution. Your duty was to tell the defense.
And I think I complied with that duty by notifying both the court and the defense of the potential existence so that they could take further action. I've tried to explain what I did. I understand your concern, Representative Evangelist. I'm not sure that I can answer your question in a way that is going to be satisfactory to you, sir.
So is it your testimony today that during the summer, spring, summer, and fall of 2012, you were not aware as a prosecutor for the Attorney General's office that there was a crime lab issue with Todd Settlemyer contaminating evidence?
I obviously was, because I wrote the memo that you've made reference to.
Don't you think more could have been done, given these 3 court decisions I just referenced? It's a requirement. It's not a choice. The state police doesn't have a choice.
As
It's
I
a
said,
requirement of our constitutional law and Supreme Court decisions that this matter be turned over to the defense, and it wasn't.
I've answered the question as well as I can, Representative Evangelist.
Thank you, Mr. Chair.
Thank you, Representative Evangelos. Representative Thorne, I saw you had your hand up before. Did you have questions for the nominee? Hearing nothing, I will just. Hello?
I do, and being a non-attorney, it won't be as pointed as Representative Evangelos. I just am curious, you know, as an attorney, you strive to become a judge, which you've been now for, is it 7 years, 6 years?
7 years.
And just on a curiosity level, being able to ask you the question here today, and I don't want to have it be cliche as an interview and a job, where do you see yourself in 5 years? But what do you hope to accomplish professionally in the years to come?
That's an excellent question. And I guess I could answer it in a number of different ways. I am delighted being a district court judge. I'm 59 years old now. I'll be 60 this summer. And I would be delighted to finish my career here. I enjoy coming to work every day. I think we deal with some of the most important questions that there are, in as much as the most important cases that come before any court, I believe, are cases involving other people's children. We talk a lot about constitutional rights, and there are enormously important constitutional rights, right to free speech, which was made reference to this morning in Justice Billings's confirmation hearing, other rights like the right to bear arms. But in my view, perhaps the most important constitutional right is the right to raise your children. And so anytime I go into a court on a child protective case or a family matter, I realize that I'm dealing with perhaps the most important thing in the lives of the parties, their children. So I'm delighted to stay here in the district court. Now, I will tell you, I have considered making an application to go to the Superior Court. And I'm not completely opposed to that, although my wife might be completely opposed to that, only because it was where I was most at home and where I did most of my work for 25 years. But I'm delighted to stay right here in the district court.
Thank you.
Thank you, Representative Thorne. Representative Babbage?
Thank you, Mr. Chair. Judge Benson, my line of thinking is I looked over your resume and so forth, and I've been dealing with conflict of interest issues in many other areas of state government, which it's always a discussion that kind of fascinates me. I wondered if you'd ever had to recuse yourself from a case.
I have recused myself in one case, and I don't think I had to. I recused myself because one of the parties had become convinced that I was not able to be fair to him. And in order to promote confidence in the judiciary, I did recuse myself. I don't believe it was a case where it was necessary that I recuse myself, because I don't believe that there was any real implication that I couldn't behave impartially. But I did in order to promote confidence in the fairness of the judiciary.
Thank you. Thank you for that. Can you help me to understand how the court works regarding new evidence in a case that has been adjudicated? Does that always go back to the same judge?
If a case has been adjudicated under Rule 60B of the main rules of civil procedure, there is a period of time that the case can be reopened. And yes, it would almost certainly, unless that judge was retired, and then it would be assigned by the chief judge of the district court or the chief justice of the superior court to a new judge to look at the record. But I think it would be the invariable practice that it go back to the same judge if that judge is still on the bench and available.
And so the idea of getting a new hearing would really be part of the appellate process, but never part of a case reopening under the original charge.
It could be part of either, because you can file a motion under Rule 60B, a motion to set aside the judgment, a motion for a new trial for the grounds of newly discovered evidence and for other grounds. There are other grounds in the rule, and that would be brought to the attention of the original judge. So if the judge were satisfied that there was an adequate basis for a new trial, he or she could grant a new trial. I have a case like that before me right now in a family case where I think I will order a partial new trial on one issue because I believe that fairness requires that there be a partial new trial on one issue. Fairness to both parties. It's a case, and I don't want to say the name of the case, obviously, because it's still pending before the court, where there were some serious issues involving a teenage child, who I believe wasn't adequately represented. The child's interests were not adequately represented at the time of the initial trial. Both of the parents were unrepresented, represented themselves, and I made the decision sua sponte to appoint a guardian to represent the interests of the child, because I didn't think either parent, and I don't criticize them, I just don't think either parent had adequately represented the interests of the child. So it's a long way of answering your question, which is, yes, it can be done two ways. One, the trial judge can do it either on a motion of one of the parties or on his own motion, or a new trial can be ordered after appeal.
So thank you for that. So when I'd like to know who determines which judge will sit. I mean, would it be statute? Would it be judicial policy, or would there be an authority, a personnel person within the judiciary, the chief, whoever, that would make that determination?
I think the custom would be that it would be the original judge, unless there was some reason that the original judge should or must recuse himself or herself, or the original judge was retired. If there was no issue like that, if there was no question about his or her competence or ability to act impartially, it would go back to the original judge. If the original judge were retired, then the chief of the appropriate court would assign a new judge to take it up.
So if I could clarify, then the idea is, I assume, always dangerous, is that the original judge would be familiar with the details of the case, and more so than a concern that the original judge might have biases based on earlier decisions. But that determination is by custom and not by statute. Is that right?
I don't think it's by statute. I think any judge of either court, either of the trial courts, could hear the case. There is a presumption, I think, that while judges might make errors, and judges do make errors, we make mistakes, we misapply the law. There's no question that judges make errors. That's why there are appellate courts. There is a presumption that judges are able to correct their errors and wouldn't act in a way that was prejudicial one way or the other. We would simply apply the correct standard if we were told that we had misapplied that standard. So the original judge would simply go back and apply, I hope, the correct standard.
Thank you. Thank you for this discussion. Thank you, Mr. Chair.
Thank you. And I would remind committee members with their questions that the comments are concerning the suitability of the particular nominee for this particular position. That was an interesting discussion. I'm not sure how it necessarily addressed that. And Representative Babbage, if I could ask you to lower your electronic hand, that makes my tasks a little easier. I appreciate that.
Mr. Chairman, I appreciate your comments. I only ask because of the varied resume that he brings to the bench. Thank you.
I appreciate that, Representative Babbage. Representative Poirier.
Thank you, Mr. Chair. And I don't have a question. I just wanted to make a brief comment about a message that I received that I just think it's worthy of throwing out there. I live in Skowhegan, and members of my community have come into contact with Judge Benson, and I did have a young man, I say young because I'm getting up there in age and a lot of people are younger than me, but this young man had been caught up in a situation. He had been put in front of Judge Benson. And basically he told me that he was caught up in himself and didn't realize that he was hurting other people. And Judge Benson wasn't necessarily easy on him, he said, but he did tell him that he had potential and that after he completed his debt to society, he realized that through the words of Judge Benson, he realized what he did was wrong and it put him on a better path. And he actually went to school. He became a welder and he now works for BIW. So I just think that the importance of having compassion and telling people that they are worthy of something better than just their actions that might not have been the best decisions in their life. But being able to tell people that they do have that potential, I think is worthy of praise of a job well done. So I just wanted to share that. Thanks.
Thank you, Representative Poirier.
Thank you, Representative Poirier. Are there other questions for the nominee? Seeing none, thank you very much, Judge Benson. We appreciate your time and sharing your expertise and what you've learned in the first 7 years in this job. Appreciate it.
Thank you.
The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement with the committee clerk prior to today's hearing. All such statements should have contained the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to that written comment if he desires. Those who wish to speak in person today registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to panelist status in our Zoom meeting, and they will be able to be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the committee members, you will be returned to attendee status and the next person will be called. I will call on people in the order that has been provided to me in a list from the committee clerk, beginning with our colleague, Senator Paul Davis. The good senator could be moved into the panelist status. That would be appreciated.
Good afternoon.
Thank you, Senator Davis. If you could, your mic is unmuted. If you could turn your video on, that would be helpful.
Will if I can. Not sure. I'm a long ways from being. Let's just start the video.
There you go.
How about that? You know, I thought some about putting a bill in to prevent anybody over 50 from having all these things. But, I didn't do it. I obviously am not too technically advanced. Senator Carney and Representative Harnett, my colleagues on the Judiciary Committee. My name is Paul Davis, and I have the distinct honor of serving Senate District 4, which includes all of Piscataquis County and parts of Somerset and Penobscot County. I feel very blessed and honored that I would be asked to come and testify on behalf of Judge Benson for his nomination to support.
Senator Davis, excuse me, could you get a little closer to your microphone? I'm having a little difficulty hearing you.
I will try to. Is that any better?
That is much better. Thank you.
Okay, thank you. As I said, I'm pleased to be here to provide testimony in support of Judge Andrew Benson for another term on the Maine District Court bench. There's a lot to be said about Judge Benson professionally, and I'll get into some of that. But first, I'd like to speak to his character and who he is outside of the court. Judge Benson has been married to his lovely wife, Alicia, for over 30 years. They are the proud parents of a little girl that was adopted by them from South Korea. I know her as Olivia, but my understanding is she's taken her Korean name and now she is known as Yoonji. I believe that's how you pronounce it. Probably I messed it up. The Bensons are very active in their community. They're involved in their parish, the Roman Catholic Church. I believe it's in Madison. They are senior lecturers and they help in any way they possibly can. I first met Judge Benson in 1994. I was the chief deputy of the Somerset Sheriff's Department, and he was working jury trials for the Somerset and Kennebec County District Attorney's Office. As heard earlier, he'd been with the legal system since 1988. He served a number of years as the assistant district attorney, and then he became a homicide prosecutor. He tried nearly 100 manslaughter and murder cases, and I am certain, as I know him, that he gave serious time, research, and thoughtful consideration into each one of these cases. He was appointed to the district court judge bench in 2014. And while he has presided over most of his career in Skowhegan, he also, as was stated earlier, he has presided in a number of different venues in the state. But what was left out was Piscataquis County. He has also, I believe, presided on the bench in Dover-Foxcroft, and I'm sure did an admirable job. I believe that, and I know that he is a very fair and honest man. I know that he has a lot of compassion, that he has done numerous things over the years to help folks out. I remember when I was chief deputy, we had a number of instances where folks really needed some insight and a hand in the problems they had. And I would call upon Judge Benson a number of times, and he was always very willing to respond. We would go over people's financial problems, over their home problems. We did everything we could, and he led the way to be a good sounding board for these folks that really desperately needed help. For those reasons and many others, I'm extremely pleased to give the highest recommendation I possibly can to this person to be reappointed to the Maine District Court. I hope it'll be a unanimous decision by you folks, and I will be happy, more than happy, to answer any question about this man that you want to ask me. Thank you. You're muted, Representative Harnett.
Yes, indeed. Thank you for your testimony and welcome to having been in front of the Judiciary Committee today. Are there questions for the good senator from Sangerville from members of the committee? Seeing none, again, I appreciate your time, Senator.
Thank you very much, sir.
Thank you for your observations. Next person I have on my list who is currently an attendee is Pamela Ames. And Ms. Ames, when you are ready, unmute your mic and put your, there you go.
Modern technology, ain't she wonderful? My name is Pam Ames, and I live in Sydney, Maine. And I am speaking in favor of the reappointment of Judge Andrew Benson to the Maine District Court. As an introduction, I recently retired from the private practice of law after 40 years. I was a prosecutor in the Kennebec and Somerset District Attorney's Office, although I predate Judge Benson by a number of years. I spent 8 years there, and then I spent 5 years in the Attorney General's office in the criminal division trying homicide cases. I, like Judge Benson, have been in every courthouse. I haven't tried cases in every courthouse, but at least I have been in every courthouse, both district and superior in the state of Maine, over the last 40 years. In 1994, I went into the private practice of law and stayed there for the next 27 years until my retirement in August of 2020. My practice was a lot of criminal defense because of the years of prosecution that I had. Civilly, it expanded to a lot of domestic relations and child protective matters. I also continued in criminal matters, including juvenile matters. In the area of child protection, I was rostered as a parent's attorney, as well as a guardian ad litem for as long as guardian ad litems have been rostered. I was a trial attorney, and I have been in front of Judge Benson, I think right from the very beginning of his 7 years of being a district court judge in almost every aspect of my practice. I'd like to present my testimony as a day in the life of a trial with Judge Benson. And when I was making my notes, happenstance was that I did it from my experiences in a child protective matter, because I agree with the panel members and with Judge Benson that these are probably the most difficult cases to try. They're also the most difficult cases to hear, and they are hardest cases to make decisions when you're making decisions about another person's child. One of the important characteristics I believe in a judge is the efficient use of judge time and court resources. I know there is a backlog in Somerset County. There always has been a slight backlog, but cases move forward. Somerset County, possibly because of this, what Judge Benson said, it's a very depressed economy up there, has the highest numbers of child protective filings in the entire state per capita. And they have for a number of years. But those cases move along, and they move along primarily because of Judge Benson. We have the dreaded call of the docket, where everybody either shows up, or now we do it by video, which is a little bit easier. But as everybody knows, trying to get attorneys in the same place at the same time is sort of like herding cats. You just can't seem to get them to settle down and say, this is when we're going to try a case. But Judge Benson is a good cat wrestler, because he sets the trailing docket with not only primary cases, but he would set it with backup cases. And he is always in touch with all of the attorneys involved. As a parent's attorney in a lot of child protective cases, they oftentimes, in the time between the call of the docket and the trial, you end up with a glitch. You end up with an issue that you cannot decide. The parties are different. When you think about your standard child protective matter, you're talking about 4 attorneys and 3 clients. So you're always in a position of, how are we going to do this? And Judge Benson has always been receptive to telephone pretrial conferences where he listens to the issue, he identifies the issue, and he solves the issue, and he will give us decisions in a timely manner so that we're not at the very last minute saying, I didn't know that I was going to expect this. That type of judicial intervention keeps everybody on their toes and keeps the case moving forward. We would also have cases that would settle, and he would always encourage the parties to come to an agreement, but he was always there saying, if you don't reach an agreement, I'm here, I'm ready, we're going to try this case. Like has been stated numerous times, when you have the deadline that it's either you walk into that courtroom or you settle, that oftentimes that case would settle. But Judge Benson would go above and beyond. He would set a time up to put that settlement on the record so that it doesn't disappear, it doesn't create more problems. And he would be accessible to the attorneys to make sure that got done in a timely manner. It was also good if you happened to be one of the backup cases that you knew your feet were being held to the fire and you were going to be next and you were going to be heard. The trial issues, as Judge Benson said, the court has to know the rules. They have to know the elements as it was put forth by the legislature as well as by the Maine Supreme Judicial Court. And Judge Benson always, in every case that I've done, has always stated to the parties in the beginning of the trial exactly what is the law, why are we here, what is the burden of proof, what are they going to have to try in these cases. And he listens to all of the parties. And that is one of the key qualities that I think, through my experience, makes a superb judge, is that oftentimes the positions that you may take, sometimes in child protective cases with parents, are not very popular. And they may not be the strongest cases in the world, because oftentimes the client is their own worst enemy. But he will listen to the argument, and he is never degrading of anyone in his courtroom. I have never had him have a derogatory remark, cut someone off in a sarcastic manner. He is the politest person in the courtroom. He always has been. Sometimes me, not so much. So I really respect when it comes from a judge as trying as some of these cases are. At the trial, he was always respectful of each party's position, their right to make an opening statement if they wanted to. He would make sure that it would be a statement, not an argument. He would keep everyone focused. He would always respect every witness, no matter who called the witness. That made no difference whatsoever. And he would listen to their testimony. One of the key factors with Judge Benson is he is the best knowledgeable person I know in my 40 years of career of the rules of evidence. I thought I used to be pretty good, not so much. Sometimes objections are inartfully made, and Judge Benson, in the politest, nicest manner, will restate the objection. He will give us the rule of evidence. He will open it to arguments, and then he will rule. I think judges that come from prosecution have a little bit of a one-upmanship in that, but Judge Benson is the best of the best. He would always give the opportunity for a closing argument. As I'm saying, I'm doing child protective cases here just as an example. And he would allow both parties to answer, to argue, excuse me, but he would also, if there was a point that was bothersome for him, he would discuss it. He would focus the attorneys on what are the issues that are most critical to his decision and let them argue that, as opposed to a blank screen and we had no idea where he was going. And the points that he would make that he was concerned about were always right on point with what is the law, what is the burden of proof. It is extremely important to the clients and to the attorneys that they get heard, that they get listened to, and they get heard and listened to in a respectful way. He was always respectful to the attorneys, to the parties, to the witnesses. Sometimes it was even the spectators that happened to be in there. And on the same note, but kind of the opposite side, is control of the courtroom. A lot of times in these cases, emotions run very high and people behave badly. Sometimes it's just the courtroom, it's just the subject matter. But people need to feel safe in the courtroom, and Judge Benson never let aggressive language or aggressive behavior even get the littlest amount out of hand. He would nip it in the bud. He would use the court officers, he would use his power, and believe me, if you get on the wrong side of Judge Benson and you are not polite, you are not respectful, he would give it back in a respectful manner, in a polite manner, but he made his point very clear. He had control of his courtroom, and it made all of the participants be on their best behavior. And that is important, especially in nowadays, that I always felt safe.
Ms. Ames?
Yes.
We typically don't have hard time limits in confirmation hearings, but if you could wrap it up, I would appreciate that. We've been at a long time today.
I certainly can. I would just like to say that in the decision making that Judge Benson has done, he was always clear. And one of the best things that he did is he would come back after he'd reviewed his notes at the end of a trial, giving everybody that opportunity. He would be considerate of everyone's presentation, and he would look people in the eye and render his decision. His decisions, you always knew why he had decided as he had decided. He gave the reasons. The reasons were based on law. They were not based on any preconceived ideas, any of personal bias. He always used the applicable law fairly. He knows the rules. He knows how to apply the rules. He applies the rules with respect. And we always ended up with a fair hearing. And that's all we can ask for a judge, but one as exemplary as Judge Benson. And I would strongly ask for this court to, I'm doing well. The last time I was in court was a while ago, for this committee to strongly urge them to support the renomination. Thank you for your time. I appreciate it.
Thank you very much, Ms. Ames, and the committee appreciates you taking the time out of your day to share your observations of Judge Benson with us. Are there any questions from committee members for Ms. Ames? Seeing none, again, thank you very much for taking time out of your day. And I will next turn to the next person on my list. I believe we have two final presenters. First being Rachel Okun from the Maine State Bar Association. If she could be moved in as a panelist. And magically, Soupy's already done that for me. Well, now, I no longer see her in as a panelist. Ms. Okun, if you can hear me, if you could unmute your mic and turn on your video. Possible we lost her, and we will do our best to get her back. But in the interim, I will turn to Jason Jabber from the Maine Trial Lawyers Association, and hopefully we will get Ms. Okun back. I could have Mr.
Good afternoon.
Thank you.
You can hear me okay?
Hear you fine. See you perfectly. Thank you.
Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jason Jabber, and I'm a practicing attorney with offices in Waterville and Portland, and the treasurer of the Maine Trial Lawyers Association. On behalf of myself and the association, I am proud to be here to support Judge Benson's renomination to the Maine District Court. A survey conducted of our members gave Judge Benson high marks for his demeanor, ethics, and skill. These evaluations echo the evaluations that we received after his initial appointment in 2014. In evaluating Judge Benson, our executive committee noted his 26 years in practice, including 15 years as a prosecutor. On a personal level, I was introduced to Judge Benson very early in my career, almost 20 years ago, when I was second chair on a defense team headed by now Justice Murphy on a homicide case. This case was prosecuted by Judge Benson, and I was left impressed by his professional demeanor and particularly his intelligence. He was a fierce and highly competent litigator, but he did it with the highest integrity. This case ended in a jury waived trial in Somerset Superior Court. And I was maybe 2 or 3 years into my experiences as a lawyer. And I was just extremely impressed with him throughout the process. Since Judge Benson's appointment, I've appeared before him often. Not surprisingly, I've continued to be impressed with his intelligence, his professionalism, and his integrity. He's a master of the rules of evidence and procedure. And despite being the smartest in the courtroom, he's also, as Pam Ames pointed out, the politest in the courtroom. As you've heard, he's skillfully adapted to handling family matters, even though his primary experience was in the criminal realm. So based on my experience and our members' high evaluations of Judge Benson, I'm proud to be here to endorse the renomination of him to the Maine District Court. I'm happy to take any questions. Thank you.
Thank you very much, Mr. Jabber. The committee appreciates your taking the time out of your day to share those observations with us. Are there questions for Mr. Jabber? Seeing none, thank you. Representative Senator Carney.
Thank you very much. Mr. Jabber, thank you for sharing your remarks today. Both you and Ms. Ames talked about Judge Benson in the courtroom and his intelligence and his mastery of evidence and how respectful he is. Could you just describe a little bit the impact that that has on the members of the public who are before the court? We've heard a lot of like the attorney perspective, but I imagine that you might have some observations of how the public reacts to him and the impact on their confidence.
Well, yeah, 2 quick examples. Number one is, when there's a crowded courtroom, it's criminal arraignment day. Of course, we don't have that in the last year or so, but back in the old days when people used to have to show up to arraignment, we had crowded courtrooms. When you have somebody like Judge Benson, who's in control of things, he certainly moves things along. He's to the point, but at the same time, he's polite. He hears everybody, and I think it gives people a sense of. I think it makes people feel better. They're nervous when they go to court. It's a big deal for them. Even though us lawyers, if we go to a procedure we've been to 100 times, we don't get nervous, but our clients do. And when you have somebody like Judge Benson, who's taking the time to talk to people, to explain things, it helps the individuals and their confidence in the system that they're being heard and that they're going to get justice. The second way I can say it is, I've appeared before him in, I can think of at least 2 contested family matters. And these are seldom easy, especially when it gets to the point where it's contested. You've been through mediation, the case cannot be resolved. And people want to feel like they have their day in court. And I alluded to this, but he is so good with the rules of evidence and procedure that his ability to run a trial and hear evidence and sift through what can be complicated objections, evidentiary objections, it definitely bestows confidence in the individuals who you're litigating for. So those are a couple examples. And I guess the other thing is sometimes when you try a case, you can be waiting a long time for decisions, which can be frustrating for our clients. And with Judge Benson, that's not the case. He's very, I think he's very concise and efficient, and he doesn't waste time issuing his decisions, which is beneficial.
Thank you, Senator Carney, and I apologize for missing your electronic and human hand. Are there additional questions for Mr. Jabber? Seeing none, and I think I'm right this time, thank you very much for taking time out of your day to spend it with us this afternoon.
Thank you. Glad to be here.
And I think we have rescued Ms. Oken. I hope I'm saying that name correctly, from the ether in between being an attendee and a panelist. So just begin speaking when you feel comfortable.
Thank you. Yes, I apologize for that. I lost my Zoom. So my name is Rachel Oken. I'm an attorney in Portland. Thank you for allowing me to speak here today. I am the principal attorney at Oken Law in Falmouth, and I am one of the Cumberland County representatives for the Board of Governors for the Maine State Bar Association. I currently serve as the chair of the board's Legislative Review and Response Committee, and I am here today in my role as one of the members of the Bar Association. I have not had the pleasure of practicing in Judge Benson's courtroom, but I am pleased to speak in favor of his reappointment to the district court. As I'm sure you all know, the Maine State Bar Association conducts surveys of all members, collects data, and asks members for feedback regarding judges and justices throughout the state. We were particularly impressed by the survey responses to Judge Benson. Actually, Judge Benson was rated good or excellent by 100% of attorneys who responded, which is, I think, pretty remarkable. That says a lot, I think, about his character as a judge, and it goes along with what all of you have been saying here today. From the surveys, it was very apparent that Maine lawyers find Judge Benson to be wise, judicious, and knowledgeable of evidence and case law. Maine attorneys describe Judge Benson as compassionate, fair, and kind to all who appear before him. I would therefore ask the committee to approve his reappointment based on the survey responses that we received. I'm happy to answer any questions if you have any.
Thank you very much, Ms. Oken. We appreciate you being here today and sharing that with us. Are there any questions for Ms. Oken regarding her testimony today? Seeing none, I am going to thank you very much for taking the time out of your day. We do appreciate it. I'm going to turn to our committee clerk. I am not seeing any other attendees that we have not heard from. I will ask if there's anybody who I might not be seeing who wants to testify either in support of the nominee or in opposition to the nominee to make yourselves known. I am not seeing anyone. Soupy, is that accurate?
That is correct, Mr. Chair.
Thank you. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee after the beginning of this hearing. Are there any such documents? Ms. Panett?
There are none.
Thank you. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA, Section 157, and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice. We are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Andrew Benson of Athens for reappointment as a district court judge is closed. We move on to taking the vote. In accordance with the law, the committee may not take the vote of the nomination sooner than 15 minutes after the close of the public hearing, unless all members of the committee who are present agree. At this time, therefore, I will ask whether any member present objects to proceeding to taking the vote immediately. If you do object, if you could raise your electronic hand or your regular hand so that I can recognize you. Seeing none, there is no opposition or objection to moving directly to the vote. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Andrew Benson of Athens for reappointment as a district court judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. The committee clerk will call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. I have 11 members voting in the affirmative, 1 member voting in the negative, and 2 members are absent.
Thank you. 11 members of the committee having voted in the affirmative and 1 in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Andrew Benson of Athens for reappointment as a district court judge be confirmed. Congratulations, Judge Benson. Typically, were these normal times, we would leave our seats at the horseshoe to congratulate you personally and to thank you for your service to the state of Maine. We can offer our thanks and congratulations, but we can only do that virtually. So it has become the 2021 practice to give you a round of virtual applause for the work that you've done and the work that you will continue to do for the people of Maine.
Thank you, folks, and thank you for the trust that you've continued to repose in me. I really appreciate it.
Thank you. That, I believe, concludes our work for today. We are scheduled to begin tomorrow at 9:30, and I take responsibility for scheduling at 9:30, forgetting that there is a Democratic House caucus at that same time. I will leave that caucus early so that I can be here for the beginning of the hearing. And I understand that might be difficult for some members, but I would ask you to get here as soon as you can if you need to remain on that caucus. I do see that Representative Thorne has a hand up, and I will turn to him before turning back to our clerk and analyst. Representative Thorne.
Thank you, Mr. Chair. I just wanted to let you know that I will be in the State House tomorrow for the meeting.
Thank you for letting us know that. We appreciate that. Representative Moriarty.
Mr. Chair, I just wanted to ask a question about scheduling for next week. Do I understand that the schedule for Thursday, April 1st for the committee is still in effect?
That is my understanding.
Okay, thank you.
Yeah, I agree with Tom. Yes, that is what will happen on April 1st.
Okay.
Are there other questions from committee members before I turn it over to, just make sure I'm not forgetting something from those two people that really run the show here? Seeing no other questions, Peggy, am I missing something that we're supposed to be doing right now?
Hi, I don't think so. I'm working from home and my phone is ringing, but my husband will get it. I think we're all set. I think that Senator Carney and Representative Harnett and I will be trying to figure out, and Susan and Sam will be trying to figure out how we deal with the House and Senate coming in next week. So we're canceling everything that we had carefully scheduled for Tuesday and Wednesday. So stay tuned.
We know that we have some work to do there, and we
Right.
appreciate rescheduling those 30 bills that we were going to be listening to or working on.
Wow.
Ms. Panett, is there anything on your end that we need to cover?
No, sir, I do not have anything for you at this moment.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Given that we're discussing scheduling and stuff, I know Senator Carney had said that we would be having a group discussion, but I'd appreciate it if it was put on an updated agenda for the end of business on Thursday.
Well, you already have our commitment that we're taking that up. If you want us to reprint an agenda, I imagine we can.
No, it's good enough. Good enough.
Excuse me? I'm sorry?
I guess it's good enough if we have your commitment, but you know, the way this town's operating right now, a lot of commitments aren't being followed through on. So, but I'll take your word for it. Thank you.
Well, I'd like to think that we have been following through on our commitments, Representative Evangelos.
Not all of it, Representative Harnett, but we'll discuss it off mic.
Thank you, sir. I would like to thank the committee members for all of their work today. Today was a long slog, but it's a very, very important work that we did. And I would like to thank all of those members of the community and the bar and the governor's office and the Judicial Selection Committee that came before us to make this process work today. Thank you very much for all you do, and we'll see you tomorrow morning.
Thank you.
Thanks.
Bye. Hey, Soupy, you're still on.